greater civil society that is in the Constitution.
Thank you very much, Chelimo. And even as we go to Bwana Garasho Motach, the chairperson of the National Lands Commission, allow me, ladies and gentlemen, to introduce to you Commissioner Omwanza Ombati, a commissioner with the Judicial Service Commission, a renowned lawyer, joining us also in this particular panel. Also, allow me to acknowledge the presence of the Chief Registrar of the Judiciary, the Honorable Winfrida Mokaya, who has joined us and later will be making remarks. I also appreciate Professor Ben Sihanya, karibu sana, Irongo Houghton, karibu sana for joining us, and karibu and asante sana for joining us this particular morning. Commissioner Ombati, I will be coming to you in a few. Let me speak to Bwana Garasho Motachi. And land rights are one of the things, because for my ground setting, I'm starting with questions on our niche. Land rights are one of the things that this progressive constitution brought to us. How would you say then that the NLC has safeguarded land rights in the past 15 years?
Thank you. Thank you very much.
Let's please share the microphone. Thank you.
Thank you for the question. But please allow me to give a context to my contribution to the discussion this morning. I'm the chairman of the National Land Commission, but I'm equally the chairman of the caucus of the chairs of constitutional commissions and holders of independent offices. There are 15 of those commissions, Chapter 15 commissions, and the independent offices, the DPP, Auditor General, Controller of Budget, and so on. Now, there's a reason I wanted to give that context, because 3 years ago, that caucus, we call it CCIOs, short for Constitutional Commissions and Independent Offices, we celebrated 10 years of the existence of the commissions. Why 10 years then? It's because after the Constitution was promulgated in 2010, there was a process of legislation and setting up of most of those commissions. For instance, the National Land Commission came into being, including now having commissioners on board in 2012. And so did many other commissions. So when we were celebrating the 10 years, we were taking stock of the gains and the challenges. And in the process, we dealt with the hits and the misses. And if you allow me just to give that context, you talked about some 8 minutes. I'm trying to see if I give a useful context. And I'm doing that also because I'm excited to see a mix here of old wazees with gray hair and young people here who say they were literally toddlers when this constitution was promulgated. Now, broadly speaking, and this applies to my commission and to other commissions, there are the misses. What is it we have missed? What is it we have not done well enough? Broadly, what we came up with then as we are taking stock, and we had a series of engagements like this one, with media. We had engagements at the university, Professor Sihanya here, they gave talks and so on. The broad issues we looked at, one was the resources. Resources, that's financial and otherwise, human resources and so on and so forth. That cut across all the commissions. And I'm sure Frida here of the Judicial Service Commission, my young brother here, Umbati, will confirm that. Now, so we have that challenge generally with being empowered in terms of resources to carry out our functions. The other challenge, another broad one, is encroachment of mandates. There is the big brother, the executive, who has always elbowed the younger brothers in the devolved government. In the same way, we have that challenge of every now and then encroachment on our mandates. Now, let me quickly come to the gains. You'll allow me just to be broad because instead of just focusing on the land sector. When we were taking stock, we realized there are so many gains. And what I can personally say, I would rather look at what the journey we have traveled, not as a glass half empty, but as a glass 3/4 full. Because at times we don't appreciate where we have come from. So for those young people who were 7, 8, 9 years I had here, even the lady next to me who was 21, you say? Two quick examples. Elections, for the longest time in history, were managed by a person known as the supervisor of elections, who was an employee in the Attorney General's office. And the returning officers were district commissioners, all under the executive. Ask any Kenyan now if they would want to get anywhere close back there to elections being managed in that manner. And that's why I say those who are young then may not appreciate that journey. Another quick example, and then I finish. Judges. Now, during the Moi era, at 1 o'clock, you would hear the announcement that the president had a very busy day this morning, and he picked Irungu Houghton as the new Chief Justice. And that is the beginning and end of the matter. Or he picked Omwanza Ombati as a judge of the Court of Appeal. That's the beginning and end of the matter. What happens now? There's a long process. You know, adverts, people apply, and what have you. Judicial Service Commission, which is independent, conducts interviews, and so on and so forth. Now, if you ask any Kenyan now, would we want to go back to that point in time where you would hear one morning the president has woken up and said, I prefer so-and-so as the Chief Justice or a judge? So I may have given a broader answer because you asked about land, but I thought I'd rather give a broader context, also given the broader view, the bird's eye view I've had as chair of the caucus.
Thank you very much. And I want to build on that broader view and now bring in Wakili Omwanza Ombati, Commissioner of the Judicial Service Commission. You want to pick or to give us a piece of your thoughts on what Bonotachi has said? Because initially, and this is a question I'll still get to, on how the Judicial Service Commission has defended the independence of the judiciary, amongst many other things. But let's start with the broader thought.
Thank you for that question and for inviting us. I would take it from where Chairman Otachi has left, that indeed the gains are more than can be seen. And it reminds me of a story that we are told of somebody who was somewhere, I think in Eldoret, and he saw some policemen come to visit him, and he thought that he had committed, a lawyer, actually a prominent lawyer. And he started running away, and they ran after him. They told him, but why are you running? You've been appointed as a judge. So indeed, it's true, as Chairman Notachi said, that the president would announce judges from the podium. And basically his word was law. That has changed greatly since the new constitution. There's a big shift. There's a big shift also in terms of how the perception of the public about how judicial independence is exercised, and how accountability also is taken care of. Now we have processes on how we recruit, on how people go through the processes of disciplinary and such things, and also ultimately in protecting the independence of the judiciary. And by saying by talking about protection is not only from the state. The threat against judicial independence can be from individuals, it can be from other actors who are not necessarily the state, but also the main issue of judicial accountability now is what is the business of the Judicial Service Commission. So in terms of the topic for today, the gains of the Constitution, safeguarding integrity and accountability under the Constitution, I would say that if you were to rate the performance of the Judicial Service Commission and possibly the other chapters, 15 commissions, you'd give them very high marks, because number one, of the challenge of resources, and number two, in terms of execution of their mandate. Yeah.
Bonotachi and Omwanza Ombati, you're saying that yes, we've made tremendous gain rather, and I would agree, but I belong to the school of thought. I'm part of the younger generation that feels we should not settle for where we are. We saw the younger generation in the streets, 2024, calling for better governance. Should we be at a point, 15 years on, shouldn't we be at a point where we have fully or are fully implementing the dictates of the Constitution? Because as we speak, you say that the executive does not have proper or no longer controls many things, but some in the audience would beg to differ, that what we are seeing, and without speaking about an individual head of state, we have seen two heads of state with this Constitution. There still appears to be overreaches. The chairperson of independent commissions, of the caucus of independent commissions, Bonotachi, says there's still some overreach. Then should we settle for what we have right now, or do we have a right then to yearn for more?
I don't think we can settle for what we have, because I think the constitutional project is a living project. You cannot say that you've achieved the aspiration of the Constitution and then stop. I think it's, normally the courts like saying that the Constitution is a living document. Actually, the Constitution is a living instrument, and each generation defines what their challenges are. And obviously what the young people raised or have been raising from last year and the year before is something that also needs to be addressed. So we can't settle. We can't say that we've reached at a place where we say that we're able to settle. In fact, this reminds me, I think, of where Obama, in one of his speeches, says that the union is not perfect. We will keep on working on it. The same way for our Constitution, we cannot say that we've reached a place whereby things are settled down. No, every generation and every moment has its own defining challenges that need to be addressed, and then the instrument is there to sort of mitigate or address those issues.
All right. Yeah. All right, Bonato, what more needs to be done? Unfortunately, I have to tie down this, and you'll understand, based on the very many institutions that our panelists are coming from, they could be limited to speak about, or not to speak about, some contentious issues. But let me come back to what your purview is. What would you say are the opportunities that we have with the current Constitution in terms of fighting corruption, and what is holding us back? Because there's still a section of Kenyans that feels, look, we are not doing as much as we ought to be doing. So what is holding us back? And what opportunities do we have? Please, let's share that particular microphone. In the meantime, you can be using mine. Great.
Thank you for that question. I think I can pick up from where Mr. Otachi left about the resources. One of the challenges in the fight against corruption is more to do with the resources. You have 50 million Kenyans, and you have, say, officers of the Ethics and Corruption Commission, 700 of them, and those 700, all of them are not technical officers. When you go to the judiciary, we have two registries of the High Court of the Anti-Corruption Division, which were gazetted. That is Mombasa and Kisumu. But you still don't have judges in those stations. So it speaks to the issue of resources. It also speaks to the issue of the resource in terms of personnel and the funds. The Anti-Corruption Division of the High Court in Nairobi was established in 2015. It currently has only two judges. And then the other thing that we need to emphasize on, we have very good laws. People have said as much. But what is the culture of Kenyans? What is the attitude of the citizens? They are more tolerant to corruption. I say so because when we engage, when we go for what they call the big fish, you find at times members of the public coming up to protect their own. So we need to kind of change the attitudes in terms of how we see the persons. Gen Zs came out because they felt that something is wrong. But how many other Kenyans have done that before? Well, we recognize that the fight against corruption is crucial, and that's why we entrenched the commission in the Constitution. We said we established the Leadership and Integrity Act. We have established the Bribery Act. Look at the administrative advisories that the EACC gives. No law obligates any institution to follow those advisories. So in as much as the laws are progressive, they are robust, there are still some things that need to be done. And I say that you talked about the question of should we stop there? All of us in this room are converts of one religion or another. Should you at one point say, no, I've reached that level, I have that now I'm self-actualized in terms of spiritualization. We still go to church, we still go to the mosque every other day. So the fight against corruption and the changes in all spheres of life on integrity and accountability is a continuous process. We have to continue to engage the members of the public. We have to continue to collaborate as institutions. We talk about independence. Independence, yes, independence in terms of decision making and the way you perform your duties. But does not mean that you disengage from the other sectors. We have the National Commission on Administrative Justice, which involves various actors in the law enforcement sector. That does not mean that the Judicial Service Commission or the judiciary has surrendered its independence in terms of decision making to the NCHA. The participants in the NCHA are to meet and see how coordinated how can we make better the fight against the corruption? How can we progress further? So the issue is seeing how we can surmount some of these challenges. The laws are there, but we need to see how to surmount the challenges that are facing us. Talk of political interference, it doesn't have to come from the top. I've talked of the instance of the public going to protect maybe a governor who is about to be arrested, or a PS or an MP who is about to be arrested. And the public are coming strongly to say this is our own. So we need to continue to engage the public and sensitize them. Thank you so much.
Picking on where Tor has left Chelimo, and I'm one person who's very proud of what the civil society is doing in the country, and of course, in conjunction with the judiciary in making sure that we stay in line. But I was listening to Professor Kivutha Kibwana this morning, and he said he would equate our constitution to a hen locked in some cage for years or for days, and eventually remove the cage, and that hen would not leave, still thinking it's caged. Do you think that is where we are? From what we are getting as examples here of Mtuwetu in fight against corruption, from what we see in places where we should really follow the rule of law, we are having the very people who gave this particular constitution a 67% approval rating claw back the citizens. The problem appears to be with us. Is this something you agree with?
Very, very, very interesting. Okay. All right, yes. So very interesting analogy, and maybe probably not too far from the truth, where there's the intentionality of the Constitution is progressive, but implementation, qua ground, is still wanting. And I know the call continuously is we need to both implement and protect the Constitution. that not to be comfortable where we are today, but what more can we do to continue to enjoy the rights, the promises that are in the Constitution. I remember seeing you on the 25th, defending 25th of June 2024, defending a young person that was being beat down by the police. And how I see the Constitution is beyond the presidency who has taken the oath to defend the Constitution, that we need to do it collectively as Kenyans. It's beyond the independent commissions, it's beyond the executive, the judiciary, that it is a Kenyan document. This is ours. How do we defend it and ensure that we understand it and hence ensure that it is implemented? Just a few examples that I was thinking about as you asked the question. Public participation. This is guaranteed in the Constitution, both in governing, but also in issues, finances, and beyond, that the public needs to be involved in the conversation and to participate. But what are the kind of frameworks that we have right now that guarantees that mwananchi, who we call Wanjiku, that is actually involved in their voices, and not only, it's not just a tick the box public participation that has been convened a day before, that we're actually interested to hear what do people want to do in this particular area and actually ensure that their voices are considered. It's good to hear the concern, the misses on the resources in the commission. As an active Kenyan, as a taxpayer, for me, I don't fully understand that concept because we pay taxes. The expectation is that the Constitution as is, because it is supposed to be implemented progressively, that the commissions that are in the Constitution should be facilitated to ensure that that continues. But of course, what holds us back is this monster corruption that then prevents us from really enjoying the Constitution and the promises that they are in. I also think about the other example I think about is issues of affirmative action. And with the lawyers here, I know we can probably take NTV somewhere in a local court and ask, why is this not constitutional? This should be, the panel should be 2/3, right? But there is a progress. For example, because the requirement on, or just how we look at the vulnerable groups, the women, the children, people with disability, the youth, and how the Constitution then not only provides the rights generally to all Kenyans, but there's this affirmative action. And looking at where we are, still not enough. We can still do more to ensure that especially the vulnerable groups in our society really enjoy the promises that are in the Constitution. So the analogy is not far from the truth, but one of those that I want to celebrate before I take it back to you, Ibrahim, is how our parents lived in a very fearful Kenyan. No one would dare do what Gen Z did on the 25th of June 2024. This was unheard of. But this Constitution, how we see it in practice, is that young people not only understand the rights that there is in the Constitution, but they are protected by the Constitution to go to the streets and say, we do not accept this finance bill, we reject it, and we call for more public participation. On this year, June 25th, I was on the streets saying we need to remember the over 40 young people that were killed by the police. And I remember, so I reflect on Article 37 that gives us the right to protest, to assemble, to picket, to provide, to give our petitions to institutions, provided we do it peacefully and unarmed. That was not the case on that day. The pushback from the police was something I had not experienced before, and it gave me going to the streets and exercising my right in Article 37 of the Constitution to really experience the pushback that we receive from the police and what
Right.
we are saying, we need to be able to enjoy
Right.
our rights
All right.
in Kenya.
And Chelimo, from you, I want to take it to Otachi because one, in your capacity as chair of Constitutional Commission, two, chairing this caucus of constitutional commissions, and three, because you're a lawyer, what Chelimo is telling us is what our citizens appear to have properly taken or understood in the Constitution, the right to picket. However, you sit at a vantage position where you see in your operations daily, and I want you to speak candidly about this, and beyond the audience here, we have so many people following us across our social platforms, citizens clawing back on their own constitutional gains. I should say selective application of the Constitution, this time not by the authorities, but by the citizens. This is something you have seen. Is it something that you want to speak to? So that we are honest with ourselves. Let's not just point fingers, but also see this is what we need to do better. Aside from only taking advantage or properly practicing the right to picket, let's also practice these other ones, which the EACC has mentioned, mtu wetu syndrome, which keeps coming. How would you speak to the citizens about them accepting the full implementation and not selective?
Thank you once again. Now, I think, as you point out, there's a need for self-reflection from the part of everyone. This constitution starts with a statement, we the people. Remember, we the people is a continuing group of people. Some die, some are born, and what have you, but we the people of Kenya have come up with this. Now, the most critical thing that I think everyone should focus on is the rule of law. And that is starting from that citizen, so-called citizen, whether they are picketing or doing anything else, and every other institution. Now, an example has been given from the ACC perspective about the citizens and how they would protect their own. Now, if you look across the spectrum of the three arms of government, you might find one arm of government seeing the speck in the eye of the other. But each of these institutions has its shortcomings. And what I think is important is for the citizens to continuously call to account each of those institutions as to what they should be doing. Bearing in mind that those who occupy certain positions at a given time will be there for a while, and they will leave. So that when you're in a particular position, you are looking at entrenching the rule of law. That's part of one of our mandates as constitutional commissions, not just for the day, but for posterity. Now, you will notice, even at the level of leadership across the political arena, you find a governor today is going to be a senator tomorrow. A senator today wants to be a governor tomorrow. An MCA wants to be a speaker, and so on and so forth. Now, once you occupy a particular position, you'll be looking at that other institution and saying they are not doing it right. You should be asking then, what should they be doing right? Someday you'll be sitting there. And that applies to every citizen who is standing up and criticizing and picketing. They should ask themselves, if I were in that position, what would I do? And how should I encourage us to do that? Again, I will emphasize, I know you asked earlier about giving up, about despondency, and so on. My view is that we should be looking at the half full or three-quarter full rather than half empty. What have we built? And even if we are criticizing and poking holes, how do we strengthen? Take a simple example of the IBC. I gave an example of how it is that elections were conducted in the past. Imagine that that is a scenario we had in terms of supervisor of election at the last 2022, the near crisis we had. imagine you did not have an independent IBC. Where would Kenya be? Now, did that IBC conduct itself in a perfect manner? It can be faulted. But you will say, we have an institution that is independent. And there's a dispute, it will go to the Supreme Court that is independent. And then we finish, we move on. Where we have had weaknesses, let us look at the weaknesses and build on the challenges. And again, maybe I will add this. Even within our own institutions, we talk about, for instance, the issue that has been raised about funding. We ask ourselves, within the institution, if you don't have the resources that you need, what do you do? Can you be more innovative? Talking about my commission, one of the major, mandates we have is addressing matters of historical and injustice. When we find we do not have enough resources to go out there physically and engage and so on and so forth, we become innovative, use virtual engagements, even in many other matters, even in terms of conducting meetings. Then you still move without having to have spent. And we have seen the same with the judiciary, which is leading in this, in conducting matters electronically. So you can be innovative and say, well, we don't have enough to eat and grow as fat as we want. But do we have, whatever we have, can we consume it reasonably and survive for the long term? Thank you.
Prudent use of prudent financial management you speak about. Wakili Ombati, the judiciary, and I lauded it earlier, has been that one arm that Kenyans feel confident to run to every time there is some extremism from any party. However, there is a concern about the wheels of justice grinding so slowly that most of the times, by the time judgments are made, decisions are made, they are, so to speak, overtaken by events. And many people would want to understand how better can the judiciary, and I ask this in your capacity as a member of the Judicial Service Commission, then serve Kenyans to the true realization of the Constitution, so that it does not take too long if I'm seeking redress.
Thank you for that question. The issue about the wheels of justice moving slow is basically about the processes. The process of conducting a case is, in our nature, adversarial. You go to court, have a claim, then you have a respondent who has to respond, then you have to bring evidence, and then the judiciary or the judges or magistrates make a determination. So part of the delay is not delay that can be attributed to the judiciary itself, but some part of it obviously can. And the way the commission has addressed that is through performance management, so that now virtually and through the electronic means, the Chief Justice is able to see the performance of each judicial officer. And there is a feedback every month about performance by an officer or a judge that they're able to receive and see and evaluate themselves, self-evaluate. And also when these things come, when they come also for interviews, those are some of the perimeters or parameters that we look at. So there is an internal process of accountability so that justice is not too slow, and that is through making sure that people actually work for what they are paid to do, and that this service is able to serve Kenyans. That is one. The other part is that those that present cases, the Mwananchi, the Wanjiku or the Mora out there who brings their case to court, they also need to be prepared on their part to present a case that is complete, so that there is a shorter time in terms of determination and things like that. So both of us have to work at it. The Commission through the accountability mechanisms, and the public through presenting cases that are complete, that have evidence, and then through the lawyers who are able to also give their input. Yeah.
All right, I'll be throwing it to Wangeshi to pick two questions from the audience. But even as Wangeshi does this, I also want you to think about this. What constitutional gain would you die defending? I use that statement very, very, very deliberately. What constitutional gain would you die defending? But let me come to you, Bonato. The Ethics and Anti-Corruption Commission, you do a good job. You do, we've seen you nab, allow me to use this very plain word, thieves of public resources. However, there is one particular thing that appears, or you appear to be falling short on. This is the full implementation of Chapter 6, Leadership and Integrity. It's not just about stealing funds or resources, but about ensuring that people in leadership, people in governance, actually have integrity. We have seen, and I know for one to run for office, they need clearance from various agencies, including you. But we still are seeing individuals acting in a manner that is not fit for their office. Yet, this week don't appear or don't seem to be looking at us as EACC. Is it something you'd want to speak to? As you answer this, Wangeshi will be moving around to take just 2 questions, then we'll come back. But Bonato, let's start with you.
Thank you for that question. As for the Leadership and Integrity Act, I think it is on record that the Act is not as originally as it was envisaged. And that is why I've talked of in as much as we have progressive laws, there are certain things we need to do to tie up those laws. When you talk about integrity vetting, and I need to be clear with this, EACC does not clear people to be appointed in offices. EACC does not clear people to vie for offices. That is not provided in law. It gives a report on the suitability of the person. And it is the institution that is bestowed with responsibility of either appointing or clearing for elections that is supposed to make that decision based on the report given by EACC. And the vetting process is one of the key areas that we have made proposals to the National Assembly for amendment, so that we have a clear vetting process, and that if EACC issues a report, it is to be considered by the institution. But you can give the institution and tell the institution, this man or woman is being investigated on corruption. But the institution, if it is about, goes ahead and appoints the person.
Before you proceed further, tell us, because you sit here, how is the uptake by the various appointing authorities that you advise? How do they take your advice? If you have some statistical data that this is the much you've told them about individuals, and this is how much they've ignored, or this is how much they've taken, do you want to tell us about that? So that we know where to take the hit, right?
I may not give the statistical data, and I wish I had that in advance. I would have provided the statistical data, but the responses by the various responsible commissions has been varied. And one thing I need to state is that EACC is not the only implementer of Chapter 6. It is the overall implementing agency. But there are other responsible commissions like the Judicial Service, Teacher Service Commission, who are supposed to enforce the Leadership and Integrity Act upon the officers whom they are superintending upon. EACC can also delegate the enforcement of Leadership and Integrity Act to specific or to the responsible commissions. I should digress and say even in the current COI bill, it is bestowed upon the responsible commissions, the different commissions and the different independent offices and agencies. So the various agencies and commissions have dealt with our advisories in a varied manner. Some have embraced it, accepted it, and people have not been appointed to offices. But of course, I don't have to tell you about the IEBC. You saw it in the last elections. We gave a report, and it is for everybody to see. All of them were clear. And that was not, it is not within the ambit of the commission. And that's why I'm saying the law should be clear. If somebody is facing corruption charges, should they be appointed? Should they not be appointed? For me, they should not be appointed. Thank you.
When your recommendations are disregarded, this is very brief, 30 seconds. When your recommendations are disregarded, is this where it ends?
We've made attempts to have a recourse to the courts. And I think one of the first cases that we went to court, a civic society went to the institution, was when the former Ethics and Corruption Chair, that is Momo Matemo, who was appointed as chair of the commission. And somebody went to court to say he had integrity issues. But the court came out clearly that in as much as there are issues of integrity in the constitution, they say that you cannot just accuse the person without taking the person through the process. So it is a lacuna in the law, say that we need to have our law so that if somebody, as I said, is facing those corruption charges, the law should be clear on what should happen. And then I talked about the IPC. The law, the way it has been made is that under Article 99 on clearing persons or disqualifying for them to file, it is until they have exhausted their appeals or review. It does not only talk of appeals, it talks of review to higher authority. So if somebody has a case in court and has not, even if the person has been convicted and has not exhausted the rights of appeal. So I think we have been having thoughts that could you change it that in as much as you have been convicted, it is until that the conviction is set aside so that you can be allowed to file.
All right.
But the person who makes the law is an interested person. And this also boils down to, Mr. Otachi talked about the judicial processes and also Mwanza. I think the problem is also our laws. The laws does not give time span, especially for anti-corruption cases. You can take a case in court and it stays up to even 10 years to go through the whole judicial process.
All right.
Yes.
All right. All right. I want to pass it to Wangeshi, and I think when we come back, you'll also, our fellow panelists, pick from where Tor has left, because I think it's really interesting. But Wangeshi, I'm sure some of the members in the audience want to throw in some questions.
Katiba yetu ni a very progressive document ambayo imetupatia rights which are non-derogable na zile ambazo government inaweza compromise. I've been listening to Mr. David Tor, and from what I am able to read from there, rather even from my document, is that he worked for this institution called the Ethics and Anti-Corruption Commission. What we do take, or how members of the public understand the Ethics and Anti-Corruption Commission, is that it is a tool, or rather it is a door used by the executive to which hand those people who are anti-government. So I am asking myself while sitting here, and I'm very sure that most people who are sitting here, they have a lot of questions. You are a legal service, you are the director for legal services. What do you advise these people?
All right.
Do you advise them to follow up those people who are anti-government, or are you objective on matters to do with the Constitution? Finally.
Question noted.
Yeah, question noted. Please, let me not go with this question. Please.
Allow us to take one question.
Yes, please. Just one final question. In a new
10 seconds.
Yeah. To the chair of the National Land Commission, it hurts me that 60 plus years, the challenges that affected Kenyans, from the time of Jomo Kenyatta to right now we have President William Ruto, issues to do with the land are still stubborn and are still hurting. What are you planning, or rather what is your plan to ensure that the historical land injustices are settled once and for all.
Thank you.
For the period that you're going to be occupying that position.
Thank you very much. Let's take one more question.
Thank you very much. There's one more here.
And gender. Yes.
So should I proceed?
Yes.
Must I stand up?
Of course,
Good morning, everybody. I am MJ Okumu. I'm an advocate of the High Court of Kenya, and I also teach law on the universities, on the University in Nairobi. I want to send this question to the chairman, National Land Commission, who is also the chairman of all the chairmen and women of the Constitution and the Constitution, from what you have told us. Now, you have really addressed us well, but there was some lamentations from your membership of the chairman of the different commissions. Now, the question I'm asking is this: 15 years you have lived with this constitution. What stops you from doing the right thing? You are the regime. Because somebody has to do the right thing the first time. What stops you? There's a question I'll ask when the full panel is in. But for now, that is my concern.
All right.
So if I got it right, it's not about the document. The problem is implementation. Thank you very much.
All right. Let's have a lady. I also appreciate questions to Chelimo and Commissioner Ombati.
Thank you. Good morning. My name is Sonia Birti, and my question is to Mr. Otachi. Sir, I just want to highlight just a few figures regarding the question that I'm going to ask you about. And that is regarding land issues and grabbing issues in areas in Nairobi and, of course, other parts. But according to a research done by Crime Research Institute, the perpetrators of these land grabbing concepts, 35.1% are the neighbors of the area, 35.1%. 21% are corrupt land buying officials, 10% is self-serving political leaders, 10% is corrupt advocates, 3.8% is landowners, and 1% is government officials. So, having been living in an area like Westlands, where you know land grabbing is an issue, and I believe I will get some deep insight from you, is if 35.1% are neighbors who are involved in land grabbing and such the like, then what hope do we have with the Constitution if a high number of neighbors are entwined in such like cartel to make sure that they get what they are looking for? So I just wanted to know from your angle, is there something that we're missing? Because we as neighbors, we're looking to sort out the issues just to find that we're actually fighting amongst ourselves. And you as the chairperson, what would your recommendation be? Thank you very much.
Thank you. Now, I will only take now, not to curtail freedom of speech, but also for the time that we have, allow me to now take questions. If you know your question is directed to Commissioner Ombati and to Chelimo only. If your question is directed to the two who've already been asked questions, ladies and gentlemen, allow me to cut you short. Questions now directed to Commissioner Ombati and Chelimo, tafadhali.
I'm Hira Mongoma. I'm talking about, my concern is about corruption. Kenya traditionally is famous for corruption. Please help me to ask David Tor. Chapter 6 of Kenya, of the Constitution of Kenya, sets high standards for leadership integrity. But still corruption still undermines our progress. My question, what practical steps can citizens and institutions take to ensure public officials are held accountable for misusing resources? Thank you.
Thank you very much.
Thank you.
That's the last question. Sir, who is your question directed to?
Judicial Service Commission? Good.
And then that's the last question we are taking, and we come to responses.
So my name is Kemboy Henry Cheruyat from Shiriki Action. First of all, congratulations Kenya and Kenyans for the Katiba at 15. My question is it time that we have parts of the Constitution being amended? First of all, because of public participation, significance, the flaws that it might have had before. I know it might not have been, or it could be part of the reports like the one a guy was saying, that they are not being implemented. So public participation has not been significant, and also making the cost of corruption high. So maybe Chelimo can also respond on that.
Thank you. Thank you very much, Ongeshe. I think we'll leave it at that. Let me start with you, Commissioner Ombati, because you haven't spoken for long. And let's start with that question, because there are quite some heavy questions thrown in the way of the EACC and NLC. One of the greatest, or one of the biggest people who command a following in this country is ODM leader Raila Odinga. He has mentioned in an interview before that 15 years after the Constitution is a good time to review a Constitution. We have seen attempts previously through BBI, through Okoa Kenya, of amending the Constitution. And the question there is it time?
Against amendments, unless certain parameters are met. You saw the big push by BBI to have it amended, which didn't succeed. And actually, every attempt to amend this constitution has not succeeded so far. So that shows about, I think that was the intention of the initial framers, or Kenyans, that they needed to protect their constitution. And unless there was an exceptional moment or circumstance that would warrant an amendment, and that will not only come, it's not only Raila who will determine whether the constitution needs to be amended or not. Kenyans have to agree, all of them at a core, that we need this. But you cannot say that the constitution has not been able to serve us. I think it has served us well. And if there is a need or a moment to amend the constitution, I'm sure that the Kenyans can agree, all of them, the way they did with the initial document, for that to happen. Yeah.
Thank you very much. And I reflect on just the thoughts that Omachi has shared. And this chapter of the Constitution on amendment is probably the shortest, with only 3 articles, precise, and clarity on what needs to be done. Every information that we will need to know what needs to be done. And I assess that when these processes, time for this process to be followed, that should be, and Kenyans have rallied behind that, and with key areas, then when that time is ripe, then probably will happen. But I see the opportunity to still really rally behind upholding the Constitution in many ways. And now I'll talk about the question that he has asked on corruption and the cost of corruption, because that's the one, the biggest disservice to the Constitution today is the high rate of corruption in our country. And when we ask what can be done, I want to reflect that the kind of leaders that we have in the different positions, both at political spaces, public spaces, are a product of us Kenyans, unfortunately. And the kind of values that we then uphold as Kenyans is what we see and are currently fighting, which is quite unfortunate. And I see the opportunity to really rally behind the opportunity to, to uphold the Kenyan values as our enshrined in the Constitution, values of Utu, and really appreciate the next person as equal to me, and to really ensure that what we do as Kenyans is to uphold the values that we desire to see in our leaders. That has been our pain point, unfortunately, and when we then, as a nation had made reference to earlier, when we then protect Mtu is with those lenses. We have the, of course, unfortunately, the lens of how can we benefit from the leader that has been selected from our region to represent our people, as opposed to the bigger goal of it's not for personal benefit, it's for the Kenyan to benefit. And you also had asked, what is the one section of the Constitution that we can die fighting for? Probably it may be very difficult to answer that question because the Constitution as a whole provides a very unified promise to all Kenyans. But of course, the sovereignty of the people and the supremacy of the Constitution, Chapter 1, becomes then foundational to how we are called to be patriotic to this country through the Constitution, and hence be able to defend the implementation of the Constitution. So as equate to Kenyans really, in how we define the values that we want to see in our leaders and hence in ourselves, and there also the challenge to really fight, uphold, and implement this Constitution.
Asante sana Bwana Otachi. There were two questions thrown your way. One asked, why are we not doing the right thing? What stops you from doing the right thing? Then there is a question from the Honorable Sonia Baldi, which I want you to respond to.
Thanks. I think there were three questions. The first question was from the NZ. About,
yes, you're right.
About historical injustices. Now, the Commission is continuously handling historical and injustice matters for the last 12 years. There are hundreds of decisions that were made over time. Some are challenged in court, some are implemented. There are many that are not implemented, but the law provides that the Commission makes recommendations. So they are implemented most of the time by other agencies. It's not much different from a court decree. A court makes a decision, and then the decree is executed by someone else. So we have determinations that were gazetted over time. There are those you can find on our website, and we are continuously processing those. As I live here, in fact, I'm a bit late for my meeting, but plenary, we are discussing some determinations today. It's a continuous exercise. If you visit our website, you find some, and there are those that are actually also in the Gazette. But of course, I also talk about limitations because of finances. There are limits to what we do, and we also lost quite a bit of time around the COVID period, when we could not engage with the public as we have wanted. The question about doing the right thing. Some, I believe, of course it's difficult to speak for everyone, but I believe the constitutional commissions are doing the right thing every day. If you come to my commission today, there's activity going on. We have processing of allocation of land, processing of payment for acquisition of land, dispute resolution. The right thing is being done every day. It does not mean some things that are wrong are not being done. Because, and I will link this to the answer I was going to give on the land aspect, land grabbing. There is something also that is part of our society. And what is part of our society are those integrity issues, where it's easy to point at others, for instance, being corrupt. Yet, as citizens, we encourage that corruption. And I cannot also say that every institution, even as they are doing the right thing every day, they are not those who are doing some wrong things. Now, just by way of speculation, I want to imagine that even at ESCC, those who follow corruption matters, I would not be surprised if there could be an officer who would be willing to accept a bribe to look the other way. We've seen it in the courts, and JSC continuously disciplines officers. So even as we are doing the right thing every day, there are those rotten apples who are doing the wrong thing. Now, to the question on land grabbing. Land grabbing is a very broad subject, but let me categorize this into two aspects. One is grabbing of public land. Now, over time, there are those who found their way, historically, found a way of grabbing land that was meant for public institutions and so on and so forth. Now, the Commission had powers under review of grants and dispositions section to recover that land, that kind of land, and that was done. There was a time limit. We did it was done for about 5 years. It stopped. In fact, the law was amended just about 2 weeks ago to give us more time for that. But under that, a lot of land was recovered, public land. ESCC is continuously also doing that, going to court to recover land that was grabbed, public land that was grabbed. When it comes to the other category of private land being grabbed, I would give this analogy. Grabbing of land by one individual, someone's land by another individual, is no different from theft or burglary. Somebody will break into your house and steal. So if somebody is grabbing your land, they have found a way of forging documents and getting your land. So we also have those kind of cases are routinely dealt with by the courts in criminal cases and in civil cases. So it's not, and maybe just to conclude, under the current constitution, land, there is, in terms of evolution, what has happened is what was vested in a commission of lands years back has been spread out. Counties have a role to play in matters of land, the National Land Commission, and the Ministry of Lands. So sometimes it's a question of focusing and finding out where is the problem. Just to conclude, I, as chairman of the National Land Commission, I have been a victim of somebody trying to grab land using my name. They go to the Kenya Gazette and put a fake notice saying the chairman is going to allocate this parcel of land. There are people at that there. Then you discover somebody is trying to use your name to steal land. So people, the land thieves are amongst the citizenry. They work in collusion with officers. In the same way, corruption generally is part of our society.
Right.
Thank you.
All right, thank you very much. And finally, Bonato, you want to respond to these questions. Ladies and gentlemen, we'll be taking a break immediately after because of the other session. Allow me, sir, not to take another round of questions. Bonato, please.
Thank you, Katiba, for those questions. And I'm happy that you are a lawyer practicing law. I wish to say that ESCC is not under any leash by anybody. It discharges its mandate as per the Constitution. The Commission is an independent commission, and under Article 249 is supposed to adhere to the Constitution and the law, and also the Ethics and Anti-Corruption Commission Act. And it processes information that it has received touching on various persons, whether in the opposition or in the mainstream camp. And particularly, as a lawyer, you know that when you find a case against a person, you may know the truth on your side, but you find the critics that have been filed say opposite of the things that the things you know. And even for the cases now that you've talked of the opposition politicians who have been handled, when they stand in their platforms, they will say how they are being victimized. But you take them aside and ask Mheshimiwa, did you do this thing? The Mheshimiwa might say, no, my officers misled me. But what is being sold outside there might be a different picture altogether. So let us process information as it comes. And let us be objective when we try to perceive what people say. People raise defenses of all manner of defenses. Whether those defenses are right or wrong, we also need to interrogate them further. But I should categorically say that EACC acts on information that is there and it processes it in accordance with the rule of law. On the issue of Kenya being famous for corruption, I would say that transparency international various countries. Kenya is not Warsaw and it's not good. So let us not kill our country and say it is the worst. We let us appreciate the gains we have made. And it all goes to individual accountability, institutional accountability, wherever we are. Let's adhere to integrity and accountability and do that which is good. Let me give you an example. Somebody gives money for a child to be recruited in the national police. The child succeeds. The person does not make noise. Another one gives money. The child is not taken. The person makes the two basic noise ethics and corruption commission. But when you ask him, why you not corrupting the person? Thank you.
A very wonderful point to end this discussion, ladies and gentlemen. We agree, right? Let's appreciate our panelists that actually mentioned as they get to sit and start with.
So maybe before we break, as Canada says, I need to introduce my colleagues. I think I think they are very to appreciate them also. They are giving support to all these processes. Maybe my colleagues can start, please. You can still put questions to them.
Yes. Before you take it, Mr. Otachi, the reason why I wanted to mention your name as you go see because I wanted to give you, as I mentioned your name, your 30 seconds of closing comments. Also appreciating your team members who are here. So I want to leave Mr. Toby, you've done that. Let me now introduce Gershom Otachi, Chairperson of the National Land Commission. Thank you very much for joining us. 30 seconds of closing comments and appreciating your team.
Yeah, okay. Actually, I want to thank you for appreciating the team. Can you stand up? There was the other person. My closing remarks is that, first of all, I appreciate this kind of engagement. I wish I would have been here for much longer, the whole day, but I will not be able to be available. But then, I am happy to have this kind of engagement where the young and the old sit together and look at issues. We have the Gen Z, who I would say at my age are our sons. We need to speak to each other and understand where we are coming from and where we are going, and also understand each other. And I'm happy to have any further engagement. Thank you.
All right, even as Chalimo comes in, ladies and gentlemen, let's appreciate the presence of her ladyship, the Honorable Martha Karamu Koome, the Chief Justice of the Republic of Kenya, as well as President of the Supreme Court. Karibu sana, your ladyship, for joining us. Thanks for joining us as well. We are just winding up. Chalimo from Forum CIB, 30 seconds of closing comments and appreciating your team that is here.
All right, thank you very much, and Karibu, Madam CJ. I want to acknowledge my colleagues from Forum CIB. You can just stand and wave. I, however, felt my time was also representing other civil society, so that if you're here, just stand and wave. Civil society, I see Houston here, and Kenyans at large. I hope I have also got your voice in this panel. Thank you that it was not just elitist and with lawyers and only commissioners, but from our Kenya here that could represent 190. So clap for yourselves. My closing would just be to affirm or to continue to push that, to encourage the commissions that we have here and others to continue to exercise the independency. We really depend on that as civil society and as Kenyans, that your voice, your actions are not bought off, that we can rely that at the National Land Commission, at ESC, at JSC and other commissions, that we need to, as indicated in Chapter 15 of the Constitution, we really depend on you being independent in how you execute your issues, and especially as we IBC, even as we talk about issues of democracy. And finally is to really celebrate and say Happy Katiba Day to all us Kenyans. We have a great instrument that is really, yes, admired by many, and we have the right, we have now the responsibility, we talk about right, we now have the responsibility to really uphold this Kenyan Constitution. And one of the ways that we can do that, and especially to the younger people, ask millennials and Gen Z to read this Constitution. Yesterday, I put this on AI, on Notebook LM, and I got on 20 minutes of an audio version of the entire Constitution. And it was a narrative, it was a conversation. So there's nothing that stops us from really interacting with this document and reading the Constitution, especially in the age of AI. So let's read it, uphold it.
Asante sana. And finally, Commissioner Omwanza Ombati from the Judicial Service Commission, your 30 seconds of closing comments.
Thank you. I would want to appreciate and acknowledge the presence of the Chief Justice. She's our chair and she's the head of the judiciary. I will yield the introduction for the rest of the team to her. And just to assure Kenyans and everybody who's here that the Judicial Service Commission takes its mandate seriously in terms of protection of the independence of the judiciary and also the accountability. And those are processes that go every day. And as a commission, we do the right thing every day, as you pointed out. Thank you.
Asante sana, asante sana. Let's give a warm round of applause to our panelists who have given us about 70 minutes of insightful conversations. Asante sana, Omwanza Ombati, Chelimo, Gresham Otati, as well as Bonato. We can have a seat right now. Ladies and gentlemen, we'll be taking a break, your leadership, with your permission. And I also want to acknowledge the president. This is a powerhouse. This is the Chief Corporate Affairs, Marketing and Partnerships Officer at the Nation Media Group, Karibu Sana Monica, and thank you for joining us this morning. Ladies and gentlemen, as we take a break, I beg your indulgence, your leadership. We started the program quite late, and we had a 40-minute break, which I want to request all of us to agree to shorten. So let's take a very quick 15-minute tea break. But before we do that, I want all of us to get our phones and do something very exciting. Very exciting. All of us, let's get our phones, tafadhali. Nataka kuona kila mtu na simu, iwe ni iPhone ama Android. Tafadhali, kama una simu yako hapa. Remember, we told you we are live. We are live on all our social platforms, and momentarily, I'm guided that we will be live also on TV. But your families and friends are not here. But they are able to follow this particular discussion on NTV. You want to know how? Because NTV has this exciting app called NTV Mfukoni, which I want all of us to get. Then send to your families and friends, right? Okay. Right?
Ibrahim, please allow us to take a break because I know we don't have so much time and there's another event that she
has to attend to. Yes. Alright, as Wangeshi comes to stage, let's quickly wind up NTV Mfukoni, should we? Very briefly. Tafadhali, on your phones, let's go to App Store or Play Store, depending on what your phone is. Naomba tafadhali, App Store or Play Store, kila mtu tufanye pamoja. We'll do this in under 2 minutes and then give the program to Wangeshi to proceed. Are we all on App Store? Let's all search, in the search bar, type NTV Kenya app. NTV Kenya app in the search bar. After we do that, you either tap download or get, depending on what your phone is. Download or get. And then once installed, open the app and log in with your email. And please, if you have feedback, send it to us via ntvapp@ke.nationmedia.com. In case you have feedback, send it to us at ntvapp@ke.nationmedia.com. Now, your friends and family who are not here and they want to follow this particular conversation or any other product from NTV, the wonderful documentaries, the wonderful programs, the talk shows, they can do that on that particular app. Wangeshi.
Thank you. Thank you very much, Ibrahim Karanja, and I'm sure many of you have been able to download the app, and from today you're able to use the app, and it's going to be an exciting day. We've just begun, and so without wasting so much time, I want to introduce to you a phenomenal lady. This particular person is the current Chief Corporate Affairs, Marketing and Partnership Officer at the Nation Media Group. She oversees the corporate affairs, marketing, partnership, including the Nation Media Foundation. Her name is Miss Monica Washeke, who's also the International Emmy Awards Committee Non-Executive Director at the CARE International Kenya, a Win Afra Supervisory Board member, and a Chiefening scholar. Let's put our hands together for Miss Monica Washeke Ndongo.
Good morning, everybody. Good morning, everybody. 15 years ago, we promulgated a constitution. I think we all look 15 years. You know, when you look back, you think what would have been if we were still with the old constitution. And that, I can imagine, would give us a lot of things to talk about. And thank you, Wangeshi, for that introduction, but in this case, I come here very humbly, first to represent our Managing Director and Group Chief Executive Officer, Mr. Geoffrey Odundo, who was supposed to be with us this morning, but he unfortunately cannot be. He passes his regards and wishes all of you a happy Katiba Day. Honorable Chief Justice and Chairperson of the Judicial Service Commission, all guests, distinguished panelists, eminent persons, and all protocol observed. I read this speech on behalf of Mr. Geoffrey Odundo. Today, under the theme 15 years later, the Constitution and us, we gather to commemorate a moment that forever changed our nation. On 27th August 2010, Kenya embraced a new constitutional order, one rooted in the values of democracy, justice, accountability, and inclusion. The promulgation of the Constitution was not merely a legal milestone. It was a bold declaration of our collective aspirations. And in this regard, if you get a copy of the newspaper, I would recommend you read an article by Professor Githu Muigai, who has written a lot about how it was not just a legal milestone. Over the past 15 years, this journey has not been without its challenges. We as a nation have faced moments of political tension, institutional strain, and social disruption. Yet, through it all, the Constitution has remained our compass, guiding Kenyans through uncertainty, anchoring our democratic institutions, and reminding us of the promise we made to ourselves to build a more just and equitable society. As Nation Media Group, we have walked this journey with the people of Kenya. We have embraced our role, not just as the fourth estate or just as observers, but as active accountability partners. Through investigative journalism, civic education, and public discourse, we have held power to account and defended the freedoms enshrined in our Constitution. But we have not done this alone. We recognize that constitutionalism thrives through collaboration. That is why we continue to engage constructively with government, parliament, the judiciary, with Kenyans and all stakeholders, challenging when necessary, supporting where appropriate, and always being committed to public interest. Our role is not adversarial at all. It is complementary. We are partners in building a transparent, responsive, and accountable Kenya. Across our platforms, whether you're watching it on the NTV app or on NTV Linear, or you're reading Daily Nation, whether you're reading it as a hard copy or you're reading it on the web, Taifa Leo, and across our digital channels, which every month serve over 63 million serve over 63 million people. We ensure we amplify the voices of citizens, the voices of government, the voices of judiciary, of parliament, of any regular Kenyan, and spotlight both the successes of our constitutions, its shortcomings, whether in devolution, and we ensure through forums like this, we provide a space for national reflection. We have stood firm in the defense of press freedom and the right to access information, always with great conviction. And on this Katiba Day, one we celebrate with all of you in the room and those watching us across our platforms, we continue to situate ourselves not just as a media institution, but as a trusted guardian of democracy and the people's voice. Let this day and every other Katiba Day remind us that the Constitution is not a relic of the past, but a living promise. A promise that must be protected, nurtured, and fulfilled. And it gives me great pleasure that on this first event of our Katiba Day, that we are in the presence of the CJ, who continuously remains as a bastion for protecting that constitution. And so it gives me great pleasure to not only invite her today and every other day across our platforms, across every event we have when we have this discussion, but it gives me great pleasure to wish all of us, not just the first panel that was great, but as we listen, as we reflect as a nation, to always stand in firm defense of our Katiba. So on behalf of Jeffrey Odundo, our Group MD and CEO, and on behalf of the people in the room that have organized this event and those who have responded to our call for this conversation, happy Katiba Day, karibuni nyote, and I look forward to engaging even further. Have a good day.
Thank you very much. Let's give her a better clap. And we continue celebrating Katiba 15 years later. I would like to ask ourselves, where were you on the 27th of August, the year 2010? Where were you? Monica, where were you? Yeah, just ask your neighbor, 2 minutes, ask your neighbor, where were you? How old were you? Were you there on that particular day? Did you go to Uhuru Park? What role did you play on that particular day? I'm expecting to hear very exciting statements. Someone asked me today, how old were you? Of course, I wasn't 18, but here we are. There are strides that we have made. Ladies and gentlemen, allow me to invite our next keynote speaker. Our next speaker has a long career within the judiciary, rising from the district magistrate to chief registrar. And this gives her a unique perspective of the judiciary reforms post-2010. She's responsible for the administrative and financial management of the judiciary and ensuring that the capacity, the judiciary has the capacity to deliver justice. Let's put our hands together for Winfrida Mukaya. Ladies and gentlemen, she's the Chief Registrar of the Judiciary and the Secretary of the Judicial Service Commission. Karibu sana. And it looks like it's a ladies' event today, yeah? Karibu sana.
Thank you so much. The Honorable Chief Justice and President of the Supreme Court of Kenya, Honorable Justice Martha Koome, Ms. Monica Washeke-Ndung'u, the Chief Corporate Affairs Nation. I recognize all members of independent commissions who are here, led by the chair of the caucus of independent commissions, Mr. Gershom Otachi. I recognize all distinguished guests, members of the civil society, all who are present here today, good morning. It is a good morning. Good morning. It is a distinct and great honor for me to be here with you all on this historic occasion when we join other Kenyans to collectively reflect on the past decade and a half of the Constitution that was promulgated in 2010. Indeed, 15 years just looks like yesterday. Let me first start by appreciating the Nation Media Group for conceptualizing and hosting this important conversation, and for recognizing the judiciary as a key player in our constitutional democracy. I dare say that being the ultimate custodian of the Constitution, the judiciary is perhaps the most important institution established under the 2010 Constitution. It has been the judiciary's role to fiercely and constantly patrol the boundaries of the Constitution, ensuring that no person or institution operates beyond these boundaries, and ultimately helping with the realization of the dreams and aspirations of the Kenyan people as encapsulated in the Constitution. We have done this faithfully together with other institutions, including constitutional commissions like the Judicial Service Commission, where I serve as secretary, the media and civil society, who have equally been vigilant in their respective roles. We will all remember that the 2010 Constitution was the product of decades of agitation for good governance, which proved costly for many, with many Kenyans paying the ultimate price for the agitation for reforms. Above all, it captured the hopes and dreams of millions of Kenyans, not just for themselves, but for generations to come. For this reason, the discussions we hold today are extremely valuable, and it is a great innovation that we can be able to sit together to reflect on our collective role and the future of our constitutional democracy. Yet, we must always remind ourselves that the Constitution is not self-executing. Its words on paper acquire meaning only when we, as institutions and as citizens, breathe life into them. The values we hold, such as integrity, inclusivity, equality, human dignity, and fidelity to the rule of law, are what transform the Constitution from text into lived reality. The future of our democracy depends not only on the words of the Constitution, but on the choices that we make and the values that we uphold. At the heart of our democracy lies one truth: all power belongs to the people. The timeless words, "We the people of Kenya," reminds us that the Constitution is not just a legal document, but the living covenant of a nation. And listening to many speakers this morning in the panel that just concluded, it is evident that there is nothing wrong with our Constitution. Indeed, Kenya has been heralded as one of the leading countries in the world with a transformative constitution. But the real test is whether we have the values to live it. We must be patriotic, to love this country, and to believe in her promise, and to always act in the service of the good of Kenya. It is therefore my honor and privilege to welcome the Honorable Chief Justice and President of the Supreme Court of Kenya, Honorable Justice Martha Koome, to deliver her keynote address on how the judiciary has interpreted and performed its role in safeguarding the new constitutional order over the past 5 years. Thank you, and God bless Kenya.
Thank you very much, our Chief Registrar of the Judiciary, Honorable Frida Mukaya. I recognize all of you who are present this morning, coming to celebrate the rebirth of our, is it the birthday, the 15th birthday of our Constitution. Madam Monica Washeke Ndungu, my compatriots from the civil society movement. In fact, when we were told to stand, people from the NGOs, I almost stood, forgetting that I left that space 23 years ago, but that's a place I still call home. It's what sharpened me and shepherded me to who I am today, so I always celebrate the civil society organization, especially for the work that you do. My colleagues, the commissioners, constitutional commissions, and the entire team of the Nation Media Group, a very good morning to you all. Happy Katiba Day. Indeed, I am honored, most honored, really, to join you for this Katiba Day event as we commemorate 15 years since the promulgation of the Constitution of Kenya 2010. I take this opportunity to extend my warmest gratitude to the Nation Media Group under the leadership of the group CEO, Mr. Geoffrey Odudo, for convening this event and for inviting me to reflect on this remarkable constitutional journey. Madam Dongo asked us where we were on the 27th of August 2010, and I believe some of us were gathered at the Uhuru Park. How many of us were at Uhuru Park? You see, we have to continue coming here so that we can remind others where we came from. So I was with these indefatigable Kenyans at Uhuru Park, and we were there not just to celebrate the birth of a new constitution, but also to celebrate a moment that represented a legal transition and a rebirth of a new nation. And to signify the importance of this day and of the Katiba, I was there as a judge, but we had to proceed to State House to take an oath of office under the new constitution, to affirm our allegiance that we will uphold, we will protect, and we will promote the Constitution of Kenya 2010. So it was not just a ceremony. At Uhuru Park, we proceeded to take an oath of office to see truly what was a legal transition and a rebirth of our nation. It was also a profound political and social moment, born from decades of struggle and a collective yearning for a more just, equitable, and democratic society. That moment of 27th August 2010 ushered in an era where the principles of good governance, social justice, human rights, equality, and accountability would be the pillars of our system of governance and social relations. For the judiciary, it was a turning point that entrenched independence And if there is anything I celebrate in this Constitution, it is Article 160 that underpins the independence of the judiciary and that the decisions that we make cannot be influenced by anybody or any institution. And this for us has refined accountability and places access to justice at the heart of our system of administration of justice. The fact that if anybody called me to influence me on any decision making, I'll remind them of Article 160 and ask them whether they have sworn to defend and protect the Constitution, and why are they expecting me or my judges to act contrary to what is stated in the Constitution. Is absolutely profound. So 15 years later, we can look back with pride at the distance we have traveled, while reflecting on the persistent challenges that continue to hinder the full blooming of the social transformation promise of the Constitution. The judiciary has undergone profound reform. We have developed transformative jurisprudence and expanded access to justice for all. Allow me to take this opportunity to reflect on that journey. The judiciary's milestones, the kind of jurisprudence that has emerged from our courts since August 2010, the achievements in expanding access to justice, and the challenges that remain as we continue to safeguard the social transformation promise of our Constitution. The Constitution of Kenya 2010 was born out of history of deep dissatisfaction with our governance system, including how we administered justice. This historical background should never depart our minds. Kenyans demanded a justice system they could trust, one that was independent, impartial, and accessible. The Constitution answered this call by mandating a people-centered judiciary, one required to deliver justice to all without delay or undue regard to technicalities. The Constitution restructured the judicial system in fundamental ways by first of all establishing the Supreme Court as the apex court, conceived as the ultimate guardian of the Constitution and charged with providing finality in constitutional disputes. Equally transformative was the reconstitution of the Judicial Service Commission, which was entrusted with the power to oversee judicial appointments and discipline, thereby insulating the judiciary from executive control. Whereas under the old order, the president had unilateral power over appointment of judges, the new JSC was deliberately diversified with representation from judges, advocates, and the public, ensuring transparency and collective accountability. Judicial reforms in the post-2010 period has been guided by the successive blueprints. The Judiciary Transformation Framework, the JTF, introduced by Chief Justice Emeritus Professor William Mutunga between 2012 and 2016, which laid a very firm foundation for ensuing rebirth of the judiciary by prioritizing institutional reform, transparency, and efficiency. This was followed by Sustaining Judiciary Transformation, SJT, under Chief Justice Emeritus David Maraga from 2017 to 2021, which consolidated the gains of the JTF and focused on access to justice, improved infrastructure, and the embrace of technology. Under the third phase of this transformative trajectory, we are now pursuing the social transformation through access to justice, STARGE, a 10-year blueprint running between 2023 to 2033. Under STARGE, we champion a very bold shift in reforms towards people-centered justice, towards a multi-door approach to the delivery of justice, towards leveraging on technology and innovation in the dispensation of justice, and ensuring that we widen the doorways of justice for the vulnerable and the marginalized who have historically been excluded from access to justice. The greatest outcome of these reforms has been strengthening of judicial independence. Today, Kenyan courts have demonstrated courage in asserting themselves as defenders of constitutionalism, earning respect across Africa and beyond. I received many, many delegations from other jurisdictions who are coming to understand how we have managed to remain an independent, impartial judiciary. We have some landmark court decisions upholding the Constitution. The judiciary's transformative role is most visible in our jurisprudence. Over the past 15 years, landmark decisions have defined constitutional governance, safeguarded rights, and entrenched democratic accountability. The Supreme Court's handling of the presidential election petitions exemplifies its central role in our system of governance. In 2013, 2017, and 2022, the court became the arena where the legitimacy of elections to the nation's highest office was tested. And in each case, the court anchored electoral justice in law and evidence adduced before the court rather than political expediency, thereby entrenching the judiciary as a legitimate arbiter of political disputes. In matters of devolution and bicameral relations between the National Assembly and the Senate, the Supreme Court has clarified the roles of the Senate and the National Assembly, affirming bicameralism as a cornerstone of the Constitution. In a major pronouncement on accountability in Senate versus the county governors and the 6 others, 2022, the Supreme Court affirmed that the Senate is constitutionally empowered to summon governors to appear before it or its committees to answer questions and provide information regarding county finances. The court further clarified that both the Senate and county assemblies possess oversight authority over county revenue, whether derived from the national allocations or locally generated resources. This interpretation was grounded in the Constitution's overarching purpose of entrenching good governance, accountability, transparency, and the rule of law, and the prudent financial management at both levels of government. To achieve this purpose, the court explained, county assemblies serve as the first tier of oversight at the local level, while the Senate functions as the second and final tier, ensuring a comprehensive system of checks and balances. One of the most consequential cases that has come before our courts was the Building Bridges Initiative case of 2022. And here, the Supreme Court rejected the basic structure doctrine as incompatible with the textually prescribed homegrown, tired constitutional amendment process in Chapter 16 of our Constitution. However, the Supreme Court proceeded to declare the proposed constitutional amendment initiative as being unconstitutional for having been initiated by the President, while the popular initiative route is one reserved for the public and not state agencies. In doing so, the court not only preserved the sovereignty of the people, but also defined the boundaries of permissible constitutional amendments. I expected you to clap for that. Protection of the Constitution. The judiciary has also given life to the principle of public participation, striking down legislation where citizens were inadequately consulted. This has been particularly evident as the question of public participation has become one of the most litigated constitutional concerns before our courts, with the courts in numerous decisions underscoring that constitutional requirements or public participation cannot be bypassed. In the emotive domain of land, the Supreme Court has addressed the land question in a manner that deals with the problem of land grabbing, and we have judicial pronouncements, such as in the case of Dinner Management versus the County Government of Mombasa, Torino Enterprises Limited versus the Attorney General, Akalan Semi versus Tarabana. The Supreme Court in those decisions has declared that title deeds obtained unlawfully and fraudulently would not be legitimized by the courts, thereby strengthening the constitutional promise that land must be acquired, owned, and managed in a manner that complies with the laws of the land. What that means in simple terms is that the Supreme Court recommended that we must always examine the history of any title before it can be affirmed. In socio-economic rights, the Supreme Court has affirmed the rights to housing and unlawfulness of arbitrary evictions. This was done in the case of Mitu Bell Welfare Society versus Kenya Airport Authority, a decision of 2021, where the court held that mass evictions must be conducted humanely, recognizing the right to housing and dignity of informal settlers. Together with the case of Musembi versus Moi Educational Center, this jurisprudence has advanced social justice for vulnerable communities. The Supreme Court has also been at the forefront of expanding the frontiers of the freedom and equality. And in the celebrated Muruateto case of 2017, the mandatory death penalty was declared unconstitutional for violating dignity and right to fair trial. In 2023, the NGO's Coordination Board versus Eric Gitari, the Supreme Court also upheld the right of association for LGBTQ persons, affirming that constitutional rights apply to every Kenyan regardless of their sexual orientation. You cannot stop people from forming an association simply because they are declared LGBTQ. Further, in the case of Monica Wangua Mwere versus the Attorney General, the Supreme Court held that the mothers of political prisoners who were violently dispersed from the Freedom Corner in Uhuru Park were entitled to compensation as their rights to freedom from inhumane treatment was violated by the state. And more recently, in Fatuma Adman Abiund Faraj versus Ruth Faith Moahasi, the Supreme Court upheld the right of children born out of wedlock to inherit from their Muslim fathers' estates, thereby reinforcing the constitutional principle of equality and the best interest of the child. Also important for media freedom, in the case of Law Society of Kenya versus Edward Kisiangani and the Attorney General, the High Court invalidated a government directive that sought to restrict the placement of government advertisements exclusively to the KBC. The court found that directive lacking legal authority, declared that they contravened procurement laws and undermined media pluralism. By striking down that directive, the court affirmed that the government cannot manipulate procurement policy to marginalize critical media outlets and underscored that all public procurement must comply with constitutional principles of transparency, competitiveness, and legality. That judgment thus strengthened both fair competition and press freedom as integral components of Kenya's democratic order. Do we have media people in the house? Taken together, these cases demonstrate how the judiciary has become the conscience of the Constitution, ensuring that the lofty ideas ratified in 2010 are translated into lived realities. They also confirm Kenya's growing stature as a jurisdiction whose jurisprudence is cited and respected across the continent and beyond. Beyond jurisprudence, the judiciary has transformed the manner in which justice is delivered. Before 2010, we only had footprints of the High Court in provincial headquarters and major cities. Now, court infrastructure has been expanded nationwide, with High Court stations and registries established in all the counties, ensuring that Kenyans no longer need to travel vast distances to access justice, especially in the High Court. Magistrates' courts have increased from 111 to 143 stations, with our target being the establishment of magistrates' courts in all the 290 constituencies. The Court of Appeal, which used to have a permanent bench only in Nairobi, now has permanent benches in Kisumu, Nyeri, Nakuru, and Mombasa, making appellate justice more accessible. We have institutionalized specialized courts through the establishment of the Environment and Land Court, the only one in Africa, and the Employment and Labor Relations Courts. These two courts, known as courts of equal status to the High Court. These specialized courts have improved the handling of specialized disputes like land issues and labor matters. These courts bring expertise and faster resolution of their domains, illustrating our commitment to efficient and context-sensitive justice. The introduction of the small claims courts, now numbering 40, has enabled Kenyans to resolve disputes involving less than 1 million shillings within 60 days, while gender justice courts and children's courts have ensured survivor-centered and child-friendly adjudication of matters. I must speak about digitization, which has been the most sweeping reform The launch of e-filing in Nairobi County in 2020 extended to all the counties in 2024, eliminating paper-based processes and creating a nationwide electronic platform for filing, tracking, and managing cases. Today, litigants can now access justice online. They pay their fees electronically and even attend hearings virtually. Real-time dashboards and online cost lists have made the judiciary more transparent and accountable. Virtual hearings and AI-driven transcription have reduced delays and expanded access to justice across the country. The judiciary has embraced and is leading the continent in embracing performance management. Every day we come to work, everybody has to fill in a form digitally to say what it is that they did. This is collated weekly, monthly, and annually, which translates to the judiciary annual report, the SONJA. For us, this has been entrenched through data-driven tools, such as the performance management and measurement understandings, which monitor productivity at both individual and institutional levels. Equally significant has been the embrace of multi-door approach to justice. The judiciary has actively promoted mediation. We want to build harmony and peace within families and communities. We are promoting arbitration, conciliation, and alternative justice system in recognition of the command of the provisions of Article 159, which mandates us to encourage alternative dispute resolution mechanisms. These approaches continue to play an important role in reducing case backlogs in our courts. The results of these reforms are evident. Case clearance rates have improved. The judiciary has become more open, more transparent, and more trusted as a forum for resolving disputes fairly and expeditiously. I have to talk about accountability, anti-corruption, and the emerging threats. Judicial accountability has been critical to consolidating public trust. And the Judicial Service Commission has been here, Commissioner Mwanza, and I saw a show by two other commissioners at the Nation TV radio explaining their mandates about ensuring independence of the judiciary and accountability. Independence goes hand in hand with accountability. To enhance public trust and confidence in the judiciary, in January this year, we established court integrity committees in every court station, bringing together stakeholders to identify and address corruption and unethical conduct. We were convinced that judiciary alone cannot fight corruption. We must work with others. We are therefore working closely with LSK and other state agencies like EACC to see to it that we root out corruption. The other day we launched a mobile application, a call center where citizens can call. And the messages learning is we do not take bribes, we do not ask for facilitation, and if they are brokers, because we also have many brokers who go in the name of the judge or the magistrate to collect money, we ask them to report, and those reports will be processed very efficiently to ensure that we root out corruption in the judiciary and in all the institutions. At a sectorial level, the judiciary, working with other agencies in the justice sector, through the NCAJ, spearheaded the anti-corruption strategic guiding framework for the justice sector, which we launched in March 2025. What this framework does is it provides a roadmap on coordinated action in tracking corruption across institutions in the justice sector. The Judicial Service Commission has, since the promulgation of the Constitution, diligently carried out its constitutional mandate of ensuring accountability within the judiciary by receiving and investigating complaints against judges and judicial officers. To date, the Commission has processed a total of 946 petitions against judges, reflecting the seriousness with which it treats fabric grievances and the commitment to upholding integrity in the administration of justice. 4 judges have been removed from office over that period. At present, at JSC, we have 95 complaints which remain pending, most of which are at various stages of inquiry, demonstrating both the efficiency and transparency of the Commission's processes. In addition, 210 judicial staff have been dismissed from the service after due process established misconduct on their part, which is a clear signal that ethical lapses within the institution will not be tolerated. Unfortunately, we don't advertise these data, these statistics, because of respect of privacy. But what these figures illustrate is the robustness of internal accountability mechanisms. They also demonstrate the determination of JSC to maintain the highest standards of professionalism and public trust. However, a new and troubling threat to judicial independence has emerged in the form of cyberbullying and disinformation targeting judges and judicial officers. Certain interests exploit social media to intimidate judges and judicial officers and thereby erode public confidence in the judiciary. Such actions undermine judicial independence, which is the bedrock of constitutional democracy. While we always welcome objective criticism of judicial decisions, and indeed it is legitimate to disagree with the judicial decisions, this must be channeled through appeals and reviews. Where one has a complaint of a misconduct, it should be channeled through the Judicial Service Commission, not through digital harassment. The JSC, in the discharge of its mandate, will continue to defend decisional independence and protect judges and judicial officers from undue intimidation. The other pressing challenge is inadequate funding. We begin to now sound like a broken record. Every time we talk about inadequate funding. Despite judiciary's vast mandate, presence of courts throughout the country, and over 8,000 members of staff, the judiciary receives less than 1% of the national budget, far below the recommended 3%. This underfunding constrains infrastructure development. Our infrastructure is the most dilapidated. Our digital program, I always worry about our aging servers and the increased numbers of e-filing, and this hampers service delivery. If justice is to be treated as a public good, alongside health, security, and education, then it must be adequately resourced. In conclusion, ladies and gentlemen, as we mark 15 years of our Constitution, I want to underscore that this is a living document whose heartbeat is the people of Kenya. Sometimes in the midst of these struggles we go through to bring the life and spirit in the Constitution, I've always wondered whether Kenyans have intimately engaged with the Constitution and owned it and known that it is for them. Because sometimes you wonder, why are we being treated as if we are second-rate citizens? The country belongs to all of us, 55 million. But when you see sometimes the way we are being treated, you wonder whether this Constitution actually applies to us, whether we own it, whether we have interrogated it. So in these 15 years, what I'm trying to say is that the judiciary has transformed from opacity and subservience to one that is independent, progressive, and people-centered. Through these courageous cases, we have determined and built jurisprudence with the far-reaching reforms. Our courts have emerged as defenders of our democracy and custodians of citizens' rights. As Chief Justice, I take this opportunity to reassure Kenyans of our unwavering fidelity to the Constitution. We shall continue to administer justice without fear or favor. We shall work with the Kenyans, and our commitment remains to the dictates of the Constitution to uphold the independence, impartiality of the office of a judge, and without fear or favor, to check the abuses of power and to defend the rights of Kenyans wherever necessary. With the continued support of all the stakeholders, I'm confident that the judiciary will remain a bastion of justice and a custodian of the rule of law for generations to come. Above all, I take this opportunity to urge all Kenyans to continue defending the independence of the judiciary as the shield that protects the liberties of every Kenyan. I thank you all for listening, and I pray that God blesses all of us, blesses our country, and blesses our Constitution, and gives us the strength to continue upholding and protecting and promoting the Constitution. Thank you very much.
With utmost humility, Chief Justice, before you take your seat, with utmost humility, Chief Justice, before you take your seat, I want to request for 4 quick photos, if you allow us, please, here on stage. The first photo will be of the Chief Justice and Monica from the Nation Media Group, Tafadhali. Let's do it from here. Then the second photo, we will be joined by Irongo Houghton, Professor Ben Sihanya, Winfrida Mukaya, as well as Faith Odhiambo in the second photo. Tafadhali, let's make this quick. The third photo, we will have the first panel, the panel that had the EACC join us. Please, let's proceed to the second photo. Irongo Houghton, Tafadhali, President Faith Odhiambo, Ben Sihanya, Professor, and Winfrida Mukaya, Tafadhali. Thank you very much. Asante sana for making time, Chief Justice. Let's have the first panel, the panel that was here in the morning. Chelimo, Bonato join this particular group. Our first panel, where is Commissioner Mwanza Ombati? Please join us. And lastly, the panel, we'll have the first panel exit, then the panel that will be coming up in the afternoon also to join. the very last photo. Thank you very much. Let's have panelists in the first panel to exit. Then those who will be sitting in the second panel, let's join in this particular picture. I'm speaking about Kipkirui Chekoni, Irungo Houghton, Alfred Makosi, and Nana Mugai. Tafadhali, tafadhali, tafadhali. And last but not least, Wangeshi and I want to also request to do this. Let's appreciate the Chief Justice of the Republic of Kenya, Martha Koome, the President of the Supreme Court. Thank you very much for making time. Thank you very much for making time to join us as we commemorate 15 years of our Constitution. As I hand over to Wangeshi, ladies and gentlemen, for a quick brief, I want to acknowledge the presence of President Faith Odhiambo, President of the Law Society of Kenya, who has joined us. Faith, karibu sana, and Wangeshi, take it away.
Thank you very much, Ibrahim. We're going to take a very short commercial break, tea break for around 10 minutes at most, and then we'll come back and have the LSK President, Ms. Faith Odhiambo, address us. And after that, we'll start the second panel right away that involves Dr. Kipkirui Chekoni, who's the Chief Executive Officer of Intergovernmental Relations Technical Committee, who's already here, Mr. Irungo Houghton,
DJ Freon. deserves recognition. Devolution has moved government closer to the people. From Turkana to Kwale, citizens can now walk into county offices and demand services. Imperfect as it is better than a Nairobi knows-it-all system. It serves as an opportunity to reconcile government policy with the peculiar needs of the people by bringing governance close to the heart of the society. However, today there are still hard questions about devolution. Should it stay? Should we reduce the number of counties? Should we keep them as is? And holding our county governments accountable have become part of the bigger discussions we have today. Judicial independence. For all its criticisms that have been raised, judiciary have saved this country more than once. It has allowed judges to boldly decide even the most sensitive disputes. The Supreme Court annulled a presidential election in 2017, sending shockwaves across Africa. As one Ugandan colleague told me, only in Kenya can a judge order a sitting president to go back and campaign and survive. This is unrivaled. Bold resilience of this constitution we celebrate today. And it's this very Supreme Court, years later, that decided the BBI case, saving the Kenyans from destruction of the Constitution. A discussion that we're still having today in terms of whether we should change the Constitution. And I dare say we should ask ourselves hard questions. Are we changing the Constitution to encompass those who are not envisaged at the time we were forming the Constitution? Or are we changing the Constitution to ensure certain political entities thrive more, cash in more, while we continue to destroy the very basics of the institutions that we should be protecting? Are we changing this Constitution to ensure that education is entrenched, protected, well budgeted for, healthcare system that should be affordable to the citizens of the country? Or are we changing the Constitution to ensure that we give longer term limits, ensure that certain officers sitting in office get to now enjoy more kitties that they can share around, while not ensuring that from Lamu to Lodwar, you feel that the government that you're paying taxes to is actually providing services to you? Public participation has become a doctrine, not a favor. The quintessence of incorporating the views of people in governance is now true and recognized as a fundamental constitutional principle, which has been brought to life by the resounding jurisprudence that public participation must never be undertaken as a cosmetic exercise to complete a checklist, but as a consequential affirmation of the sovereignty of the people. And I must quote now one of the infamous memes, "The people shall." The Bill of Rights, Article 19 through to 51, has transformed citizens from mere subjects to right bearers. The rights and fundamental freedoms therein are today claimed loudly and without apology. When Gen Zs took to the streets in 2024, Article 37 on the right to assemble, demonstrate, picket, and petition were their shield. Independent commissions and institutions, those struggling, exist as constitution guardrails. The Office of the Director of Public Prosecutions, the Auditor General, the Controller of Budget, the Kenya National Commission of Human Rights. These are no longer services offered by the state as favors. They are constitutional obligations owed and intended to protect the people. However, there is the hard truth. The promise of 2010 is not fully realized. Our Constitution stands tested by greed, undermined by intolerance, and often betrayed by those who swore to defend it. As we reflect on the Constitution at 15 years, it's impossible to do so without turning to the architecture of our governance. The three arms of government, the framers of the 2010 Constitution, envisaged a delicate balance, an executive bound by the rule of law, a legislature faithful to representation and oversight, and an independent judiciary committed to justice without fear or favor. These three arms are meant to act not as competitors for power, but co-guardians of the constitutional promise. Yet, as our nation has experienced, especially in the heated months following the Gen Z protest of June 2024, each arm has been tested, sometimes rising to the occasion, sometimes faltering under the weight of politics, corruption, or inertia. It is this spirit of honest reflection that we must interrogate how each have performed, what gains can we celebrate, and what dangers must we confront moving forward. The executive is the face of the state. It's meant to provide leadership, policy, direction, and protect the public interest. Our presidents since 2010 have all sworn the oath to protect and uphold the Constitution, yet each one has at some point tested its limits. Thanks to our Constitution, the presidency today operates under clear constitutional checks. Its powers are no longer the relic of absolutism and imperialism of eras past, but a public trust to be exercised in the interests of the people. Devolution has clipped centralized control, where the president is seen as a deity, as the head of the executive. The people now more than ever have a greater sense of self-determination than ever before. However, the shades of who we once were continues to stain our national fabric. The Gen Z protests of 2024, for instance, exposed deep fractures between the state and citizens. Instead of embracing dissent as a constitutional expression, the executive first dismissed young voices as misguided, then responded with force before reluctantly opening the door to dialogue. Heavy taxation policies, coupled with ballooning debt, has left Kenyans disillusioned. Many now say rightly that leadership has turned into a cycle of revenue collection without accountability. The fruit of political leadership is no longer service to the people, but an opportunity for self-enrichment for those closest to executive power. Institutions continue to crumble under the weight of weaponization, with the threat of denied budgets and removal of office holders. This runaway interference with oversight bodies and treatment of independent offices as extensions of cabinet is a scourge in our journey to constitutionalism. As one activist put it during the protest in 2024, this is not the Kenya we voted for. This is the Kenya we must resist. The legislature, our parliament, must tread carefully here, because I know Hansard is patient and reporters in the room are merciless, but truth must be spoken. Parliament was designed as the people's watchdog. Instead, it has too often become the people's auctioneer. Parliament, ideally the marketplace of ideas, today risks being remembered as the marketplace of deals. Allegations of Sokohuru in the Senate, where governors pay to avoid grilling, have undermined parliamentary oversight. Members of Parliament allegedly receiving tokens, lofty tokens to pass the Finance Bill 2024, despite the clear will of the electorate whom they were elected to represent. The head of state recently came out guns blazing against parliamentarians, citing their insatiable appetite for handouts at the threat of holding legitimate processes hostage until their side requests are achieved. As Makueni Senator Dan Manzo also warned, we are running the country through bribes. A parliament that is commercialized ceases to be a guardian of the people. It becomes a trader in justice. Ladies and gentlemen, when lawmaking becomes business transaction, the rule of law becomes a casualty. The judiciary. The judiciary remains our last line of defense, but it too is not beyond reproach. The Judiciary Fund was established under Article 173 of the Constitution of Kenya 2010 to guarantee the financial independence of the judiciary. The Constitution provides that the fund shall be administered by the Chief Registrar of the Judiciary and should consist of monies allocated by Parliament, grants, or donations lawfully made. The Judiciary Fund Act of 2016 operationalized this constitutional framework by granting mechanisms through which judiciary could directly access its funds without reference to the National Treasury, thus insulating it from executive control and political interference. In principle, the fund was meant to secure institutional autonomy and strengthen the rule of law by ensuring that justice delivery is not constrained by financial manipulation. Despite this progressive legal framework, the operationalization of the Judiciary Fund has faced major hurdles. While the fund is now technically functional, the National Treasury has continued to retain undue influence by controlling exchequer releases. This undermines the very essence of financial independence envisioned under the Constitution. As a result, the judiciary has remained underfunded despite its constitutional entitlement. The law requires that the judiciary should be allocated at least 3% of the national budget. Yet, past 3 financial years, it has consistently received less than 0.92%, far below the threshold. The financial constraints is struck according to the State of Judiciary and the Administration of Justice report, the SOJA report of 2023-2024. The institution accumulated pending bills amounting to Kenya shillings 811.17 million, up from 608 million in the previous financial year. These include Kenya shillings 410 million in the development bills and 331.92 million in recurrent bills, alongside 69.24 million in court and arbitration awards. The rise in pending bills is directly linked to exchequer release challenges and chronic underfunding. In the year 2023-2024 financial year alone, 516 cases were filed, and to dispense with them within a year would have required an optimal funding of 64 billion. However, only 21 billion was allocated, leaving a staggering shortfall of 43 billion. Even on a per-case basis, the shortfall is alarming. While the judiciary required Kenya shillings 85,050 per case, only Kenya shillings 40,700 was allocated. This translates into underfunding of 20.7 billion, leading to stalled projects, delayed case resolutions, and the suspense of crucial judicial services. Notably, the Chief Justice in 2024 suspending the hiring of Court of Appeal judges due to budget cuts, a move that directly undermines access to justice and worsens case backlog. The problem is compounded by political climate. While the judiciary received 23.7 billion in 2025-2026 national budget against its request of 40 billion, members of parliament allocated themselves 73 billion, 3 times more than the judiciary allocation. This glaring disparity illustrates the prioritization of political patronage over justice delivery. The chronic underfunding undermines judicial independence, weakens public confidence in the courts, and threatens constitutionalism itself. Ultimately, the Judiciary Fund remains a constitutional promise yet to be fully realized. Without adherence to the 3% budgetary requirement and genuine political will to insulate the judiciary from fiscal strangulation, the courts will continue to struggle to deliver justice in a timely and effective manner. I'll be remiss if I speak about the judiciary without talking about the Judicial Service Commission. The Judicial Service Commission was formed as the guardian of judicial integrity and must be beyond reproach in both process and substance. Yet it has faced mounting criticism from making summary decisions without the rigor of thorough investigations, a practice that risks undermining both fairness and public confidence. Justice by its very nature cannot be hurried, even by those entrusted to guard it. If the Judicial Service Commission is perceived as cutting corners or dispensing with due process, its moral authority to demand accountability from judges and magistrates, from court users, or even other arms of government is weakened. How can it credibly insist on integrity, transparency, and accountability for others when its own processes are questioned? We must therefore urgently reform Judicial Service Commission procedures to ensure investigations are exhaustive, hearings are transparent, and decisions are reasoned and accessible to the public. The Commission should not only uphold constitutional and legal thresholds, but must also be seen to do so. Ultimately, the Judicial Service Commission's legitimacy rests not on its powers it wields, but on the confidence it inspires. To restore and sustain public trust, its processes must reflect the principle it seeks to enforce: due process, fairness, transparency, and accountability. Only then can it stand as a credible watchdog over the judiciary and demand accountability from others without hypocrisy. Judicial overreach. There is the fear of judicial overreach, where courts, in zeal to protect rights, sometimes wade into policy and politics. In doing so, the judiciary risks unsetting the delicate balance of powers carefully crafted in our Constitution. Let me be clear, I would rather have an overzealous court than a silent one. A passive judiciary is an accomplice to injustice, for silence in the face of abuse is never neutrality, it's complicity. Yet even as we defend the activism of our courts, we must remember that the balance is the foundation of justice, as Aristotle once reminded us long time ago. The judiciary's authority comes from raw power, not from raw power, but from legitimacy, from the confidence that its interventions are necessary, proportionate, and grounded in law. When courts are seen as consistently venturing to domains best left to the executive or legislature, they risk inviting backlash, undermining their own independence, and weakening the very rights they seek to protest. Thus, the task is not to restrain the judiciary in silence, not to unleash it without limits, but to nurture a principled balance, bold enough to defend rights, restrained enough to respect democratic processes, and wise enough to know the difference. This is the true essence of judicial statesmanship. As our Constitution marks 15 years, we are compelled to ask, how well has it lived up to its promise? The progressive text of 2010 envisioned a break from impunity, inequality, and exclusion. Yet 15 years later, we are confronted with a sobering reality: implementation gaps, resistance from entrenched political interests, and a growing generational demand for accountability. The promise of transformative constitutionalism remains alive, but its path is contested. The wider constitutional landscape and looking at other challenges we face under the Constitution. Looking at the housing challenges, Article 43 of the Constitution guarantees every Kenyan the right to adequate housing, yet for millions this right remains aspirational rather than tangible. Affordable housing has for many been more of a political slogan than a lived reality. Rapid urbanization, land speculation, and skyrocketing property prices continue to place decent shelter out of reach for ordinary citizens. And more than ever before, the reality that you're not assured that the land that you're staying in tomorrow will be yours. We continue to see greater corruption in the land ministry. We have a lot of cases of individuals. Today you own land, tomorrow it has been changed to someone else's name and it has been resold. Companies purportedly taking over and owning your property. We even see public schools that we attended when we were young now being subject to grabbing. The corruption must stop. Education challenges. A crisis is looming in Kenya's education sector, threatening to undermine one of the Constitution's most fundamental promise, the right to free and compulsory basic education. The State Department of Basic Education is staring at a Kenya shillings 43.4 billion budget shortfall in the 2025-2026 financial year, with the learning of nearly 1 million secondary school students under the free education program hanging in the balance. At the heart of the crisis is Kenya shillings 21.85 billion funding gap for secondary education. Rising questions about the sustainability of the free primary and secondary education programs that has been the cornerstone of education access for decades. Appearing before the National Assembly Education Committee, Basic Education Principal Secretary Bello Kipsang sounded the alarm, urging members of parliament to intervene lest the constitutional right to education becomes a hollow promise. The numbers are stark. While the department sold 76.73 billion to support 3.24 million learners, only 54.8 billion has been allocated, leaving thousands of students vulnerable. Even as members of parliament such as Julius Meli and Ibrahim Abdul question the accuracy of projections under the shifting 844 to CBC transition, the bigger issue remains clear: the mismatch between policy commitments and fiscal realities. Unless questioned, this shortfall could roll back gains in access, equity, and the dignity of education, eroding public trust in the state's ability to honor its constitutional obligations. And I urge our fraternity in the media sector, what we need to watch is next year, how much will headmasters be charging for school fees? Because this is going to be the greater injustice that is looming. We'll have children stopped from going to school because they will be served by high school fees bills the moment that realization comes that there's no funding for education. We will go back to school dropouts, our children not having equal opportunity. And therefore, I urge the media, next year, January, is the time to watch. We must hold our government accountable, because when they sit and they pass the budgets, they must pass those budgets, take into consideration the promises that have been made. We cannot allow that when the new constitution came into being, free primary education was something that was a promise that started, that it ends with this government, not under our watch. Healthcare challenges. Universal healthcare remains aspirational. Families still fundraise on WhatsApp groups to treat chronic illnesses. 15 years after the promulgation of the Constitution, the right to health enshrined under Article 43 remains under strain. Kenya's healthcare system faces a complex web of challenges that threaten equitable access and quality service delivery. The closure of key donor programs, including USAID support, has compounded the strain on an already underfunded system and exposed the dire state of Kenyan healthcare. At the Regional Health Promotion Conference in March 2025, healthcare experts and policy makers raised urgent concerns over financing, transparency, and accountability in resource management. Dr. Abraham Rugo, Executive Director of Bajeti Hub, highlighted the paradox. Kenya funds 85% of its healthcare needs, yet patients continue to face shortages of life-saving medications. Corruption and financial mismanagement siphon resources, leaving ordinary Kenyans to bear the brunt. Counties allocate 23 to 30% of their budgets to healthcare, yet primary healthcare, which accounts for 90% of service delivery, remains chronically underfunded. In contrast, referral hospitals consume 120 billion, nearly 10% of the national healthcare budget, leaving the bulk of Kenyans underserved. The transition from the National Health Insurance Fund to the Social Health Authority SHA system has been marred by inefficiency and confusion, with implementation scores declining from 46% in December 2024 to 44% by February 2025. While some technical improvements such as e-contracting and patient verification have been made, these have been overshadowed by failures in claims management, reimbursement models, and the financial stability of healthcare providers. Public dissatisfaction with SHA remains high. Citizens face confusion about the relationship between SHIF, SHA, and Taifa Care. With unclear enrollment procedures, limited coverage, and inadequate benefits, many essential treatments and medications are excluded, forcing patients into out-of-pocket payments, a direct violation of the constitutional mandate to ensure accessible and affordable health care. Poor service delivery persists, hospitals are overcrowded, infrastructure is inadequate, staff levels remain inefficient, and delays in care continue to frustrate patients. Despite the introduction of SHA, the financial burden of healthcare has not eased, undermining the constitutional promise that health is a fundamental right. And I dare say today the biggest question that we now are haggling over is, where did the money go to these non-existent healthcare services? And even after degazetting them, the question is who will be held accountable, what investigations are being done. We're waiting to see who EACC is going to catch, and how will that money be recovered? Because that is the bigger question. It's not just about degazetting. This money ought to go into the rightful institutions. This money ought to help Kenyans who are struggling. But we are funding non-existent institutions, and yet we seem that that is the norm. Media. The media was constitutionally recognized as a cornerstone of democracy under Article 34 of the Constitution, envisaged as a free, independent, and pluralistic space. The article guarantees freedom of the media. This freedom is central to accountability. However, media must be both free and responsible. The time has come to strengthen the Media Council of Kenya to ensure journalists are protected from political harassment while also holding standards of professionalism. As President Thomas Jefferson said, "Were it left to me to decide whether we should have a government without newspapers or newspapers without government, I would go to refer to the latter." Yet the pressures of political capture, economic survival, and digital disruption now test its integrity. As the Fourth Estate navigates state intimidation, disinformation, and the peril of self-censorship, we must ask, is the media still a watchdog for the public good, or has it become a victim of both state overreach and market compromise? Data, digital rights, and the kusalimiana culture. The digital space has become both the new frontier of rights and the latest battlefield of control. From surveillance technologies and data misuse to online expression and digital activism, the struggle to safeguard rights under Article 31 is urgent. Yet alongside these tensions, we also have witnessed the resilience of a unique Kenyan phenomenon, the kusalimiana culture, where citizens share contacts of others, deploy humor, memes, and satire online to challenge power, resist oppression, and build solidarity. While difference in opinions is appreciated, it cannot be at the expense of civil liberties and human rights of other people. It's important to expose the rights of others to violations simply because of discontentment with their views, performance, or affiliations. Independent institutions. The 2010 Constitution deliberately dispersed power by creating independent institutions as guardians of accountability and the rule of law, designed to operate free from political interference and undue influence, and tasked with enforcing accountability and the strength of the rule of law. Institutions such as the EACC, we continue to see a mixture. Sometimes people approve, and sometimes there's great disappointment. From the vetting of many of these politicians that now sit in office, we've continued to see a ping-pong between the EACC and the Office of the Director of Public Prosecutions. An independent body mandated to undertake investigations must do so within the confines of the Constitution and all relevant laws. We have seen the EACC make public statements on investigations carried out in public offices, and further giving details of the same, and also indicate they have forwarded those files to the Office of the Director of Public Prosecutions. However, sometimes instead of convictions, we get more of PR statements, which continue to dishearten the public. The same is a double-edged sword, because one, it creates legitimate expectation to the members of the public that these cases will be watertight and that they'll ensure conviction. But the other side is that if that's not the case, then it's an abuse of office, as the same will put those particular individuals to public scrutiny and censure and judgment in the court of public opinion, only for the evidence not to be sustainable. I told you it's long. I warned you. But I'll wrap up. But we are only 15 once. So the reality is that these officers, as they carry out their duties, they must carry out responsibly without abusing the very power that they are granted. The Office of the Director of Public Prosecutions as well has come under scrutiny about the accountability and strengthening of the rule of law in how it deals with the cases. The National Police Service are central to ensuring justice is done, particularly in cases of corruption, economic crimes, and threat to public integrity, and more so scrutiny that it has come under, particularly the use of violence against citizens, particularly protesting openly in public without destroying any public property. The DPP must remain truly independent, exercising prosecutorial discretion without fear or favor. The National Police Service, on the other hand, in particular the Director of Criminal Investigations, must stop behaving as investigator and prosecutor, conflating investigative functions with the role of deciding outcomes in court. Justice must be dispensed in the steps of Mazingira House must not be dispensed in the steps of Mazingira House through press conferences or trending hashtags. Kenyans demand conviction based on evidence, law, and due process, not performative displays of power. The civil society has come under greater scrutiny. 15 years later, we saw for the first time in a very long time, I would say I read stories or hear stories the way FIDA was attacked in its nascent years. But in July 6, 2025, the Kenya Human Rights Commission offices were violently disrupted. About 20 armed men entered the compound, assaulting activists and journalists while looting equipment, moments before a press conference to address disappearances, extrajudicial killings, and legal protests. We have seen civil society also being labeled as protecting terrorists, facilitator of terrorists. 15 years later, the struggles that we still suffer with. I'm trying to wrap up. The Law Society is not an NGO, it's not an opposition party, it's a statutory body established under the Law Society of Kenya Act with clear constitutional mandate. The Law Society is a guardian of public interest in matters of law and justice, serving as a critical check on unconstitutional actions by the arm of government and supporting citizens' rights through legal education, litigation, and advocacy. We monitor legislation, executive, and judicial processes and ensure they conform to the Constitution and respect of the rule of law. We have faced attacks. We have been called supporters of terrorists, but we make this abundantly clear. Intimidation will not make the Law Society cower. Our duty is not optional, it is statutory. When a lion sits quietly in the cold, it does not mean it's turned into a cat. Let us therefore be in no doubt the Law Society of Kenya will continue to roar in defense of the Constitution, the rule of law, and the rights of all Kenyans. Our vigilance will not waver and our mandate will always guide our actions. The next phase of our constitutional journey must be about fidelity to the Constitution, not convenience, strengthening institutions, investing in justice, healthcare, education, and housing, building a culture of accountability where corruption is punished, not negotiated, and protecting civic space and guaranteeing digital freedoms. As Chinua Achebe once said, one of the truest tests of integrity is blunt refusal to be compromised. 15 years on, the Constitution has not failed us. If anything, we have failed it. The Gen Z generation have reminded us of this truth. They have shown us that sovereignty belongs to the people, not to those in office. Let us therefore recommit not just to the letter of the Constitution, but to its spirit, for ourselves and for the generation to come. Thank you.
A better round of applause for President Faith Odhiambo, the President of the Law Society of Kenya. You know, when you get to listen to what Faith says and the length of that speech, then you get to know the place that her heart is in terms of constitutionalism. That is what, to me, it speaks to. People who are passionate about constitutionalism and the rule of law will always, always have something to do, because that is passion. That is a desire that she wishes. Or that's her desire. That's what every person who's passionate about this would do. Speak deeply about it. Right about now, because of that lengthy, very insightful speech, I want to invite Brian Aseli on stage real quick for 30 seconds. I know we're in ties and everything. Let's just break this mood kidogo. 30 seconds, Aseli. Naomba kila mtu asimame. Aseli will show us something kidogo.
DJ, cut the music. Hello, everyone. Hello, everyone. You may have your seats. You may have your seats. It's okay. I want us to start with a fun game and then we'll get to the next part, okay? Hey, you all serious with ties? Yeah. Employment. Hey. My name is Brian Aseli. I go by the moniker, not you, by the moniker most bankable host in Africa. I work for Nation Media Group. I'm here to just make sure that everyone is doing their work. I'm supervising the MCs. That's what I like us to do. Right now, I'd like us to do a simple exercise. So every time I say police, okay? So it's a story, police, thieves, and then Gen Zs, okay? If you can hear me, clap once. If you can hear me, clap twice. Yes, so that's the exercise we're going to be doing. So every time I say police, then table 1, 2, and 3 will clap, okay? So police. Very nice. And then, so we'll have these ones over here, and that last table will be thieves, okay? Sour thieves. Okay, clap once. So every time I say thieves, we clap. And then the Gen Zs, the rest, 1, 2, 3, and 4 will be Gen Zs. So Gen Zs, so when I say police, thieves, Gen Zs, nice, that's a good exercise. So I'll tell you a story. So in the middle of the city, the police were planning a massive crackdown. Reports had reached them that a group of smart, stylish thieves was stealing not just money, but Wi-Fi and vibes. But then came a twist. The Gen Z were involved, not stealing, but just recording everything for TikTok. So the question was, is it the police, the thieves, or the Gen Z's fault? So I asked myself, is it about the police, the thieves, or the Gen Z's fault? Now, reports have reached them that a group of smart, stylish thieves were actually walking towards the police. Now, so it became a big question of police, thieves, Gen Z's, police, thieves, Gen Z's, police, thieves. Stand up. Simame. Do me that song. But before we even get there, you are all going to dance. Okay? Are we together? Yeah, just stretch your hands kidogo. Touch your neighbor, even if they have bodyguards. Nothing is going to happen to you. It's a team activity. Turn to your neighbor, tell them you look amazing. So, and then tell them we are just about to dance. Okay, so this dance is very simple. So, everyone put your hands in the air. Both hands in the air. And then put your hands on your shoulders. And then put your hands on your waist. And then you move 1, then back 2, then you turn, okay? Hey, kama mdosi wangu wamefanya. You're not beyond that pay grade. Let's do it. DJ, twende kazi. So this one, you just, don't put your hands in the air. Just walk around. Just release the stress. Release that stress. Then we go like this. 5, 6, 7, 8. Put your hands in the air. Then to your shoulders. Then to your waist. Then you 1, 2, turn. Let's go up. To your shoulders, shoulders. Then go to your waist, waist. Then you 1, 2. Let's go up. Let's go. Let's go, let's go. Let's go. 1, 2, 3. Ongeza madoido, madoido. Mr. Hotoni Rungu, madoido. Hey, let's go. Then you go. 1, 2, 3. Again. Up. Then to your
shoulders, then shake your waist like you're in primary. 1, 2. You may have your seats. Thank you so much. You may have your seats. Thank you so much.
Let's appreciate Brian Aseli one more time, ladies and gentlemen. And that session by Brian Aseli takes us to the next session, which is our second panel discussion, which is about the role of institutions in defending the Constitution and the future of Kenya's constitutional democracy. I have the honor, ladies and gentlemen, to invite on stage to contribute on this particular topic, Dr. Kipkurui Tepkwony. Dr. Kipkurui Tepkwony is the CEO, Intergovernmental Relations Technical Committee, IGRTC. The IGRTC, for coordinating intergovernmental relations between the national and county governments, he is at the heart of making devolution work. As he makes his way on stage, ladies and gentlemen, let's put our hands together for him. Also joining us in this particular discussion is Irungu Houghton, a household name, a gentleman who is the Executive Director at Amnesty International Kenya. And Amnesty International Kenya, or Amnesty International, is a global human rights organization, and its Kenya chapter is a vocal advocate for human rights as enshrined in the Bill of Rights. Irungu is a well-known human rights defender and social activist who has for decades worked to hold power accountable. Let's appreciate Irungu Houghton as he makes his way here. Asante sana. And also joining us right now, Alfred Makotsi. He is a policy analyst. Alfred Makotsi, as a policy analyst, provides a critical and informed perspective on how policy dynamics have influenced the implementation of the Constitution. He joins us, and like I said, there are those who say it is time to amend. As a policy analyst, does he think that it is time to amend? And last but not least, we are joined by Nganga Wangare Mwegai. Nganga is a constitutionalist, economic rights advocate, and a brand strategist, a Gen Z as it comes. Nganga is 29 years old, and he majors in political, economic, and constitutional civic education and public engagement, drafting political manifestos, policy formulation, public petitions, and brand strategy for human and corporate brands. Ladies and gentlemen, let's
2 cabinet ministers were overheard saying, these were NARC cabinet ministers, so 2 months after the promulgation, this constitution is going nowhere, we will kill it. And I want you to just get that this constitution has survived by the grace and by the courage of citizens and some state officers to make sure that it is a framing document for our nation.
Thank you very much. Mr. Alfred, what's your contribution? Where were you a day like today, 2010 of August 27th?
I think, thank you so much, Nation Media Group, for this forum. 2010, I think I was in high school. I was not privileged to vote for this constitution, but in my civics class, I think my history teacher, Mr. Baraza, was one of an ardent supporter of the Yes campaign, and I too, as a follower of history since primary school, and following the events that happened in the 70s, 80s, and 90s, I really wish that this constitution came into place, and I was very happy. I was not out to Uhuru Park, but I think I felt that I'm in a country that I'm growing into a brighter future. Of whether the constitution is a piece of paper or not, I think I couldn't first agree more with the Chief Justice. And to answer that question, it's a yes and no. I can see fairly old folks in the room, and they would tell you, and you would read, that back in the 90s and in the 80s, you couldn't have such a meeting, first of all. And if you sneak and have such a meeting, I think you would face dire consequences in torture chambers, police stations. So with the promulgation of the new constitution in 2010, and you are seeing that we have a day to just reflect on the constitution, I think it means that there is something that has changed. Right now, we are seeing even the power of social media, injustices faced by the late Albert Ojwang, ordinary citizen calling out, speaking truth to power. That means the constitution is working. But it's also a no, because in as much as we are seeing this, we are seeing some retrogressive elements or ideas that are trying to pull down the gains that I think our heroes fought for towards contributing towards the 2010 constitution. I still believe that devolution is not at its optimum in terms of working. We still see monies being denied to counties. We still see lack of accountabilities, even in the few monies that are given to governors. So it's both a yes or no answer, and it is a journey. And this journey, we are called upon that, yes, some of us who are there voted for this constitution. Others are coming 15 years down the line. Others will come after 15 years. We all have a role to play towards implementing this constitution. I think that's my contribution.
And we'll come back to you to also talk to us more about policy and also political interference. But Nganga, you are only 29 years of age, if I got it right. Where were you? And if you are not there, what you found, are you happy with what you found?
So what I'll say is that naturally, if I'm 29 years old, then I was there.
Of course.
So naturally I was there.
Did you know about the event? That's what I mean.
What I'd like the people to know is this, my story with this constitutional is so personal. It is so personal that it's almost unbelievable, because on the 3rd of August 2010, I was 13 years. I'm turning 29 years on 16th of November. So I just say I'm 29 because it's just around the corner. So on that specific day, 3rd of August, I'll never forget it, my dad beat me up very badly. That was not, he projected too much on me because there had been questions on whether I'm his child or not. Of course, I think because I was existing, they shouldn't even have worried. So he beat me so much, and just a few days before that, he had beat my mother so much. So as part of their reconciliation, he said, hata hiyo maneno yenye ilikuwa hapa ni ulisababisha. So it wasn't really settling on me. I was 13. How him beating my mother has anything to do with me? And I was a very disciplined kid. I never had a problem with school. I was always the top student. Now, that third, he beat me so much. I have marks on my body to death. So I couldn't sleep home. I went and slept at our neighbor's place. Then when I was sleeping, we were listening to the radio. And then I heard that the Katiba imepita. I didn't listen because I wanted. That was the only thing I could hear that time. Katiba imepita. I didn't know what it really meant. Then a few weeks later, I remember now again, it was on 26th August. On a Thursday, and the paradox is they were going for that weekly prayer. That's why I don't like the church. I don't like people who go, I don't like religion that much. Because they were going for prayers. So that day we quarreled with my younger brother, just the normal way kids play. It was 4 years. And then he came after me, and I had to run into the farm. So he couldn't follow me because he was well dressed. So angenifuata angechafuka. And he told me he'll kill me. So that is the day I left home, and I went to Nakuru. So around, I arrived in Nakuru around 3 a.m. in the morning. Then the first thing I encountered in Nakuru on that 27th is the procession that was going to Afraha Stadium to promulgate the Constitution. 15 years later, he's so proud of me, and I'm so proud of him. Like we both did our, everybody, it was the necessary evil. So my experience with this constitution is that personal. So on whether it is a piece of paper or not, I'll say this. It will continue remaining a piece of paper until the day we make it so familiar. If we do not focus on chapter 2 of this constitution, the Republic, right? Jamhuri, which says Kiswahili is the national language, or official language, right? National language, I mean. More than 80% of Kenyans speak Swahili in the most literal way. So this document will remain a very foreign thing to them. It will remain just a published piece of paper if it is not explained to them in the most literal way. A good example I'll give. I was listening to Faith speaking. I come both from Trans Nzoia County and Nyandarua County. If she was giving that speech in my village, people would have left. Because it makes the constitution seem too foreign. So that is why in my civic education, I make sure I bring it down to the common man so that they understand it is not a foreign document. It is not for the elite. It is our document. I hope I've answered your question.
Thank you, Nganga. And that's a very good story that you've given us, and the personalization, or how you take the constitution matters to you more, and I hope you continue with that journey. And you've talked about people understanding their mandate. I'll come to you, Dr. Chepkoni, on how people on the ground, because devolution is one of the gains we count from this Katiba. But what has been your mandate and the institution mandate to make sure that we have a better functional working relationship between the national government and the county governments?
Thank you. Thank you for that. And that is a very touching story from my brother there. Now, on the mandate of the independent constitutional commissions and semi-autonomous commissions that, or institutions that are in the Constitution, IGRTC is now, picking from where my brother left, for lack of a better definition, is the former TA. Because most people, through the process of 2010, all through, TA, Transition Authority, was more pronounced than IGRTC. So our mandate as IGRTC then is threefold. One, we serve as the secretariat to the summit, where the governors, 47 governors, and the president convene to discuss matters of national interest for policy direction and legislative direction. So that is the first mandate that we have. And so that is why I said earlier on, without then the Constitution, in exclusion of such entities, then the Constitution is not there. Our other mandate is to be able to proceed and conclude the functions that were left by Transition Authority. That is the transfer of functions, assets, resources, responsibilities, powers to the counties or to the two levels of government. Because McHugh, we are not only transferring functions to the county government, we are also transferring functions to the national government. Thirdly, would be the facilitation of harmonious coexistence between the two levels of government and county governments. I would leave it at that because we have about 7 mandates, but more specifically, to be able to address and celebrate these 15 years. Is one, I'll tell you today, as the Secretariat to the Summit, how many summits have been held, how many resolutions have impacted the Kenyan society from these conventions. As we speak, we are planning for the 12th summit. That in itself gives you an answer. What does the law expect us? The law expects us to convene at least twice in a year. So do simple maths, you have an answer there. And Irungu will tell you, among the reasons why that has not happened, is one, beside the comment that was made, that he has referred to, there have been attempts at even doing away with intergovernmental relations, especially at the second circle of devolution, because there was a misunderstanding of the functions and the mandate of intergovernmental relations. As we speak now, the circle now is changing. We are now realizing that we need such institutions for the existence of devolution and for effective implementation of the Constitution. Why? Today, 2 weeks ago, we were able to gazette assets of former defunct local authorities for purposes of transfer to the county government. That's how many years ago? It should have been done immediately after the transfer of functions, because the principle of the Constitution is resources follow functions. So functions were transferred and gazetted. It will have been followed by resources. So beside what most Kenyans hear about resources being the financial resources, there are also attendant resources that need to go to the two levels of government. So that tells you that constitutionalism and implementation of Constitution, we are not yet there. We are still progressing. Secondly, I would then mention that looking at intergovernmental relations technical committee mandate, that has brought the harmonious relations between the two levels of government. Between 2013 and 2017, I was privileged to have served as a member of County Assembly in Nandi. Trust me, the relationship between the national government and county government, I wouldn't compare it with the relationship between a dog and a cat. It was worse than that. However, progressively now, with the realization that the Constitution has provision, Article 6 of the Constitution, interdependence, that these two levels of government must exist in not a competitive but collaborative manner. That is what now, the phase that we are in now, where we are finding now 2 levels of government. You remember the MES program, the medical equipment program, where the counties were forced to agree and pay. As we speak, we now have a new scheme of medical equipment where governors have consented to. And there is a general agreement between 2 levels of government, and is expected to improve services to the counties. So it tells you the growth in implementation of the Constitution is progressive. Where I sit at IGRTC, if I was to project full implementation, specifically of intergovernmental relations, I'll tell you 4 things. 1, the matter on transfer of functions. As we speak, we are now experiencing where one level of government, in full view and consideration of the constitutional provisions, is desirous of transferring a function that is constitutionally assigned to that level to another level of government. Look at the school feeding program. It is a national government function, but national government has given it to some county governments. Some county governments have also asked national government, look at the issue of the markets. County governments have asked the national government to help in capacity building by co-funding the markets program, which markets are fully devolved functions. So to me, I look at a more growth in the collaborations between the 2 levels of government. However, I'll be quick to mention some 3 gaps. 1, accountability between the 2 levels of government. If you were to review the speech by Madam President, the accountability that we are asking of the national government, are we asking the same of the county government? Are we using the same yardstick? That is a gap that for me needs to be addressed as we go beyond 15 years. Secondly, intragovernmental disputes. As we speak, there are active disputes between neighboring county governments.
Maybe, do you have any specific that you have helped in resolve?
I will mention that are existing and what we have been able to resolve. We have intragovernmental disputes. I will give an example, an active example of Nyandarua and Laikipia County government, which they have taken themselves to court, but now we are facilitating the collaboration to be able to solve that matter. So there are quite a number of intergovernmental relations that we have been able to facilitate. And if you look at the court cases between 2013 and 2017, between a county government and national government or national government agencies, the numbers will go high. Between 2022, so to speak, upwards, the cases have diminished. Because why? We have enabled ADR, Alternative Dispute Resolution, through the provisions of Intergovernmental Relations Act and the Constitution. So that I don't lose track, if you allow Wangeshi, the gaps that for me exist that need to be addressed. I talked about accountability. Secondly is what I mentioned about intragovernmental. And I want to be specific here because there is one tremendous leap front that we did in the last 2 weeks when the president signed the independence of finances to the county assemblies. For the last 15 years, the county assemblies have been at the mercy of the county executive. That is a huge gain. And so what do we expect? We now expect more oversight by the county assemblies over the executive. That is a gain in the implementation of the Constitution. And so with that, we expect also disputes that will arise between the county assembly and the county executive. Fourthly, is on the issue of public participation. We speak about public participation. We are happy about public participation. But today, Hotonia, when I was in the county assembly, we started a process of legislation on public participation bill. How many years later do we have a substantive public participation framework? Even at the county government, because I would speak for the 2 levels of government, even at the county government, have we ever realized, the other day we were from Devolution Conference, and I'm happy that the team for this year's Devolution Conference was more on inclusion. Do we have a realization that when we were running away at the national center of power on marginalization, of small tribes, that now in the counties, there is even more marginalization and inequality. How then do we address that? Because if you look into the Constitution, those gaps exist, and those are when, what for me, I would say, if a 15-year-old was in where I come from, in the Rift Valley, a 15-year-old boy is due for circumcision to make him a man. I leave it at that.
We still have more, but let's get to Bill of Rights, where that's actually again from the 2010 Constitution. Irungo, from where you sit, do you think there are gains? And if there are gains, what are the gains? And secondly, what are the gaps that still exist? We have seen people being abducted, and we are still celebrating the 15 years of the new Constitution.
So I think over the last 15 years, we've seen a number of gains that arise from the Bill of Rights. Just to mention that our previous Constitution did not have the kind of expansive Bill of Rights that were there. In fact, the previous Constitution would have legitimated parents beating their children. It would have legitimated teachers beating students. It would have legitimated police officers acting with impunity. So there was a great shift. I think if I look back over the 15 years, there's probably like maybe even 10, 15, I was trying to do this morning, 10 or 15 victories that arise from communities, if I can just focus on this, communities rising up and challenging various things. And I think, you know, if I think back to the social justice centers, they are a product of the constitutional framework. The Madare Social Justice Center, legal empowerment centers that said that actually because you are poor and you are male and you live in an informal settlement, the police do not have a right to shoot you. There are examples around women's feminist movements. She Leads Kenya back in the late, I guess it was 2018 or so. My Dress, My Choice, 2014. And the most interesting one, I think, to date has been the End Femicide campaign that not only put this issue of women being killed, not because they're human beings, that's what you call homicide, but being killed because they are women or they are girls. They put that on the national agenda. Now, of course, sometimes the state doesn't know what to do with a good idea. But the fact of the matter is that if there had not been 10,000 women and a couple men, including myself, who were on the streets in January and December last year, we would not have seen the task force emerge or even the discussion move to the point that it has moved. I think, you know, I think back to a number of communities who experienced mass evictions, the Kibos community, who rose after they were, 3,000 of them were made homeless in about 4 hours during COVID-19. And as I arrived the next morning to Kisumu to provide solidarity and to start helping the lawyers to construct a case, I just saw the kind of devastation that is just unbelievable. And these were people who had in some ways worked 18 years in Abu Dhabi and Dubai and other places, built a home back in Kibos, and then had this thing destroyed, this community destroyed in just a few hours. They went to court and they found the court in favor of their constitutional rights. Or the case of Mukuru kwa Jenga, where 40,000 residents were basically bulldozed over 3 days, 16 kilometers from where we're sitting right now, and the media did not pick it up until several days later. And maybe just to put myself in there, Amnesty International did not go within the first day to provide solidarity and support. That community still sits on that land to date, and it's because they've been able to go to court and to frustrate the attempts to grab that land. So I think there are many examples that I would give along these lines. In terms of the challenges, over the last, I guess it now would be the last year or so, we have seen probably the most serious deterioration of the right to assembly, the right to free expression, and the right to life. More than 100 cases of enforced disappearances, probably about 160 cases of unlawful killings by police officers of peaceful protesters, and many of them have essentially been killed while bearing no arms, while protesting peacefully. And we have seen the targeting of bloggers and influencers online. The Law Society, Defenders Coalition, the Kenya National Commission on Human Rights, the Independent Medical Legal Unit, The Gen Z movement themselves have essentially risen not on the basis of some moral argument, but on the basis of a constitutional argument, that they have the right to protest, they have the right to dissent. And that is the space that is still being fought for and contested as we speak today. And it is important that we do not cede that space, because the darkness that some of us remember back in the 1980s and the 1990s will return if it has not begun to return in small doses. So we have to make sure that the culture of fear, the culture of bullying, intimidation, that culture does not return to the state or to the 47 county governments. Let me stop there.
Thank you. Before we move to Alfred, Irungu, you recently got appointed by the president to be part of the panel that will be leading in compensation of protest victims. Maybe to comment on that as a gain and how you would like to achieve that, bearing in mind you're part of a panel that also has political players.
Yeah. So this is probably one of my personal boldest decisions, and I balanced the dilemma. The dilemma was, is this a serious proclamation by the President of the Republic of Kenya? The second part of that dilemma was, we know very closely, very intimately, at least 350 families whose lives were upended by the violence over the last 8 years. Not just the baby of baby Pendo, but the 60 victims that are currently seeking justice in our courts under the International Crimes Act for crimes against humanity. 47 counts under the International Crimes Act is what they are seeking to hold commanders and police officers accountable. Amnesty is providing legal representation for those families. So I balance between, is this real or is it important enough to go for? And as you probably have seen on X, I have accepted the application or the nomination, and essentially this is the rationale. A tremendous injustice has happened over the last 7 years. I can not tell you how many times I have been in mortuaries, I have been to gravesides, I have been to gullies and dump sites, including the one of Kware, where we are told 47 women may still have remains in that quarry, Kware quarry that's in Nairobi. I went to Shakahola, I've been to Yala. There are a number of families that we forget once the headlines fade. Those families are some of those families I met last week, 20 of them. I met the mother of Eric Mutisia. He is the young man who was shot in Parliament by a KDF officer. I listened once again. We go to court regularly with the family, the parents of Rex Masai. I listened again to their views on compensation, and what they told us was that they demand compensation. In fact, the word that some of them use is reparations. Secondly, they said that the compensation must not come at the expense of justice. They want the criminal prosecution to continue. Thirdly, they want an assurance that there will be no reoccurrence, that there will be no families that have to bury their young people simply because they raised their views or they marched in the streets in their neighborhood. Reparations is an international human rights obligation on all states. It doesn't matter what we think about this current administration. It will be an obligation. It is an obligation on this administration. If they fail to do this properly, it will be an obligation on the next administration. And therefore, in order to maintain a victim-centered process, Faith, and I can add her here, she has left now, but Faith and I discussed this, and we came to the conclusion that some of us who have walked with these families for over 8 years, we must be part of the panel, because it is only if there are some of us inside that we can understand what is happening and make sure that corruption, diversion of resources, or an insignificant sum of money does not become the response to the trauma that we have seen. In terms of how I would like it to play out, and again, it's early days, the announcement was just yesterday, there are probably five elements that would constitute success for me. First of all, that there is significant compensation. If we can promise footballers 2.5 million shillings for a 90-minute game, then I think we can be respectful of families who who have lost their loved ones by giving a significant figure. Secondly, let us not allow this process to deny families the right to judicial redress. There are officers, there are commanders that essentially were responsible for the death of Kenyans. Those processes must continue. They must not be traded against a payout by the state, even if it is significant. The third one is that they should be public hearings. Because if you build a culture of not forgetting, not ignoring, sweeping under the carpet, trauma, mass trauma particularly, then you build a culture of respect for the rule of law and consequences that come with that process. And the fourth one is there has to be a promise that the violence will stop, that Kenyans will have the right to demonstrate, they will have the right to picket, they will have the right to express themselves, and even if they politically disagree and oppose a ruling government, that right is also contained within the Constitution. Those are my expectations. I'm not sure whether we will get there, but I am playing for that. If there is a point at which it becomes clear that this is praise and worship, that this is public relations, that it is hush money, you can be sure that there will be, I guess, a requisite response from some of us who have been appointed to the panel.
Thank you very much, and that's a very good place to also now get to political interference. He talked about if this is going to be praise and worship. Alfred, from where you sit, and I know we don't have much time, what has political interference has to do with these constitutional reforms and the journey that we have walked 15 years later? The influence, has it hindered us from implementation of this constitution?
And again, I'd say yes and no. We are 15 years old in implementing the Constitution, and we had the old man, Mwai Kibaki, may God rest his soul in peace, having among the first baby steps in implementing the Constitution. And as I could see and experience, we never had a lot of interference in terms of implementing the Constitution. But I think successive governments, right from 2013, Kenyans expected that with the new Constitution, the provincial administration would not hold so much power as they are having now. So political interference is real. And in this spectrum, I'd like to say that political interference is not only for the politicians, let me say in the executive or legislature. Even we've had very retrogressive judgments by the judiciary when the Constitution is very clear on the way forward and how certain cases should be treated. Right now we are having over 100 young people being prosecuted as terrorists in a terrorist court in Kahawa. If we go by the definition of terrorists according to international law, I think those young guys should not be in that court. So I think all of us have a role to play, and politicians world over, 90%, will always try to be crafty. That is why you are seeing some of them are really fighting for the CDF to be entrenched in the new constitution. Others are fighting for the position of the Prime Minister. It is incumbent upon us as civil society, individual citizens, to stand up and speak truth to power. And that's why I had, I was like, before Irungu actually shared the expectations of when he was appointed, I had some doubts of whether you should take it or not, because you people, you and Faith are the creme de la creme of human rights defenders in Kenya. So if you happen to entangle yourself, we're asking ourselves, who will defend these young people? Who will speak for these people who are abducted? But I can see your mind is clear on what you want and what you want to achieve. I think you should not shift the goalpost. And we are here to support you, just in case you realize that maybe it's a PR game or another game that is normally played. So political interference, as it is, remains the biggest obstacle towards the implementation of the 2010 Constitution.
Thank you, Alfred. Nganga, from where you sit as a young person, do you feel included? Many people previously, we are looking at a Katiba where you people found it, or as you're growing up, you're getting to learn the content of the Katiba. Do you feel like this Katiba includes the young people? Do you think we should have amendments? And if we should have amendments, which articles do you think we should amend?
This is what I'll say, and I've waited for people to say this, and I want you to know this, that I'm not a leader of any sorts. I'm just a voice of my generation, and I want you people to understand this. The topic of the day is about the role of institutions, right? In defending the Constitution and promoting constitutional democracy, right? Why are we not to, it is time for the fourth institution. We always say, it is time for the people as an institution. For 15 years, it has been about government as an institution in defending this constitution and promoting its democracy. What the 2024 June protest meant was this: it is time for the people as an institution to ensure that we are not late anymore, because we had been so late. So what I'm saying right now is the role of the people right now. I don't care about government, because governments will always be complacent. And I always give this example. If Professor Anyang' Nyong'o wanted the government of Kenya to have a long-term vision in 2003, and it took Mwai Kibaki 3 years to even consider it, then it means governments will always be complacent. If the constitution-making process started in 2000 and we got it a decade later, it means governments will always be complacent. If Goldenberg or Anglo-leasing happened in the 90s, and I got to hear about Goldenberg in 2007, 2008, it was still there, it means governments will always be complacent. So what is the role of the Gen Zs? I want to tell you today. Our role is to ensure we are not late anymore. This constitution was not written for government. It was drafted for the people. So what is our role? What is our role in ensuring that the constitution is defended, it's promoted, it's upheld? Our role as a generation is to identify as many problems as possible. So as long as government will keep making problems, causing problems, then we shall also keep providing solutions. That was the whole point of our education. We went to school so that we provide solutions. So our role as a generation or as the people is to ensure we identify as many political problems as possible, as many economic problems as possible, and as many constitutional problems as possible, then provide solutions. Not to give complaints to government. You cannot be the problem and then again we come to you to beg for solutions. You will not do it. So what I'm saying is this: our role is to look for constitutional solutions or constitutional-based solutions to all political and economic problems. That is our role as a generation. What I am trying to say is this. Look at chapter 12. You don't have to read the whole of chapter 12. You just have to read the principles upon which chapter 12 was founded. And ensure that we read that, we read the related acts of parliament, and ensure that if there is one that goes against it, then Article 2.4 comes into play. Will government do that? Will government ensure that no, let the Public Finance Management Act do as the Constitution says? No, it will not. So it is the role of our generation to ensure the drafters of this Constitution were so smart. I think that is chapter 16, amendment of this Constitution, right? It has only 3 articles. They ensured, we should never even think of it. So how do you tell me you want to amend the constitution and you have not fully implemented it? What exactly are you trying to amend? Yet all these chapters are interdependent. So you have to ensure that the whole constitution has been implemented from the preamble to the schedules.
Nganga, this constitution has been termed as one of the most progressive constitutions in Africa. Are you saying, and is it right for everyone in this room to say, that the problem is not the document, the problem is us people who are supposed to implement it?
You're a very smart student. You got me right. There is That is exactly what we mean. Look at this. If the executive cannot be connected with the truth, that we look at the executive and the first thing we feel is that they are lying. Do we blame the document, or do we blame that arm of government, or do we blame the occupants? When we say Mwai Kibaki, we feel, economic progress. He was there. And what I keep saying about Mwai Kibaki is this. He still had the old constitution and he never used it. Mwai Kibaki, through all the way up to 2010, he still had the old constitution, which allowed for so many things to go wrong. So what we are saying, the problem is we lack political goodwill. That is everything. That is what this discussion should be about. I think we are among the only countries in the world that the constitution has even guided you on how to vote and who to vote for. That is chapter 6. Leadership and integrity. How you'll select your leaders and what you are supposed to measure them against. So will we still sit here and cry and cry? That's what my generation is saying. We shall not cry anymore. We shall not discuss problems, because the more you discuss problems, I always say this, my father is the saddest man in the world. Why? He's too informed, but he feels powerless. And it's simply because he reads this constitution as a document. He does not read it as a tool to empower him to take action. The youth, we keep thinking that it is the role of the youth. When the guy for IGRTC was saying that there is intergovernmental or inter-county disputes and everything, it's because we keep defining ourselves along tribal lines, yet the Constitution does not define us like that. The Constitution defines us as children, as the youth, as women, men, and people living with disability. If 15 years later we still think that there is opposition, you know, we keep saying that if viongozi wa upinzani, and the media should stop saying that. The media itself should read the Constitution. You cannot keep saying that the leaders of opposition in government. No, this Constitution does not provide for opposition in parliament. Once you've been elected, you only have the majority and the minority of government. You are the government.
That's true.
The opposition are the people. We are the opposition. So if you have been elected, you are no longer opposition.
Nganga, I wish we had more time. I wish we had more time, but please give a round of applause to my panelists. Thank you so much. I wish we had more time to even give you your last remarks, but Karanja, from where I sit, tells me there's no time. But thank you so much. This is a conversation that we'll keep going, and we can keep talking about it. If there are X spaces, please join and give your views. Thank you so much. God bless you. Karanja, over to you.
Let's give a better appreciation to the panel. I think this panel is injecting, to use Gen Z terms, properly injecting, and really appreciate you finding time and joining us. Thank you very much for staying with us up to this long. Right about now, always say, we leave the best for last. A very short session, I request, because we have all sat through the presentations, the panel discussions by each or every other organization. Let's sit through this very important presentation. And I want to invite on stage Professor Ben Sihanya, a professor at the University of Nairobi, professor of law. He focuses on teaching and mentoring, a constitutional democracy and governance expert. He has so many research papers on constitutional democracy and governance, innovation for sustainable development, technology transfer and commercialization, electoral law and justice. We spoke about time to amend the constitution. You all remember that? This gentleman here, Professor Ben Sihanya, was at the heart of the BBI process. So you really want to get insights from his presentation. Professor, karibu sana, and take it away.
It can't be me to keep you away from your constitutional right, Article 43, right to food. So, how many minutes, Mr. Karani? So that we respect to Heshimiane?
Let's do 20 minutes.
That's okay, thanks. I'll respect that. Okay, so I was... Okay, thank you. Let me thank the Nation Media Group for this opportunity and all those who have participated here. And let me also say that I observed the appropriate protocol. The CJ was here and so many officials have been here. So I was asked to address this question of sustaining constitutionalism, building the next chapter of Kenya's democracy. And I added a word there before democracy. I added the word constitutional. When I talk about it's constitutional or constitutional, I added the word so that it's constitutional democracy. Democracy that is governed by constitutional rules. Briefly, I've divided my presentation into three main parts. The one is the question of the promise. Number two is the question of hits and misses. Number three, hello? I'm sorry, hello? Hello? Can you hear me? Hello? Sorry, thanks for that. Is it better? Is it better? So either I bend or I raise the technology. Technology must comply. Is that okay? Is that better? Is that better or I... yeah, help us come. Thanks. Is that better? So technology is to serve us, isn't it? Okay. Okay, thanks. So I was asked to address the question of sustaining constitutionalism, building the next chapter of Kenya's democracy. And I took the liberty to add the word so that it is building next chapter of Kenya's democracy. For constitution or constitutional. I've divided my presentation into three main parts. The first two are much easier. One is the question of the promise of the Constitution 2010, which we call transformative, revolutionary, and progressive. Those words don't mean the same thing. Number two, there is the question of hits and misses. Others call it gains and losses. Others call it challenges and opportunities. Again, the first two parts have been addressed very well this morning and this afternoon. So number three for me was the question of a set of three questions. I tend to work with the three-pronged framework: implementation, enforcement, and law reform. And that's where I really focus so that I don't have to go. Let me repeat, I don't have to go through the details on the promise because that was addressed. I don't have to go into the details of hits and misses or gains and losses or challenges and opportunities, but I focus on the question of where do we go from here, as some people say. Of course, I know we'll go for lunch and to our homes, but metaphorically, and where do we go from here as a country? So I divided this into implementation, which also relates to administration and operationalization. And I think on that I won't do much, partly because there has been a debate for a long time since 2010 that the main task of any administration, any government in Kenya, the main task of all of us, the main task of the president, the governor, and all the top officials, the CJ, the speaker, and all the officials, top officials, is to implement, to help in administration, to help in operationalization of the Constitution. And so that has been the main talk. And I agree that, yes, that is the main job. And this is work that must continue. There has also been debate, but what do we mean by implementation, administration, operationalization? How does that relate to another concept, which I've also heard today and historically? Enforcement. Are those those terms, are they coterminous? Do they mean the same thing? Not necessarily. So enforcement has also been an issue, and many times people talk about enforcement by law enforcement officials, including the police that we were talking about here, you remember, including the top officials, including, and many times also people talk about enforcement by the judiciary, etc., etc. And again, are we done? No. There are so many challenges. There have been so many opportunities, and etc. And I think on that one, I wanted to just highlight something here, that I'm aware that I'm one of those, and many people, many speakers here, including the President of LSK, many have said that the judiciary can do better. I think even the CJ has said that there are certain challenges and others. But there are some areas which I want to highlight that I feel, and it's debatable, that the judiciary has done reasonably well. There are areas such as public participation. For example, the judiciary has done much better than the legislature. And public participation was initially developed by Justice Odunga in the High Court, the Kiambu case, where the government of Kiambu, and that has happened in most of our counties, by the way, but that was the first case. They felt that, the county assembly felt that once the people have elected them, they are the ones who make laws, they don't need to refer to the people the way it used to happen. And as you are aware, in many of our counties, it has been said that public participation, and all the way to the Supreme Court. So the courts have done very, very well on that, but don't mention presidential election petition apart from 2017. Because that there, I think there has been a serious problem. But then the death penalty issue, I think the Supreme Court has been struggling to get it right, the Muruatetu case. And I think there's a lot of effort to try to make it right. I did not go into the details. I think the Supreme Court has gotten reasonably well on the consequences of impeachment, like in the Sonko case. Even if there may be problems, I think they've tried. In my view, I am clear in my mind that the Supreme Court has done a very well, excellent on the NGCDF case. That, please, MPs, county assembly officials, by MPs I mean National Assembly and Senate, your role is mainly, there are many three, sometimes there are more than three, but they're essentially three. To do what? To do what? Legislate, represent, and do what? Oversight. Again, I have heard the latest rumor in town has been that some MPs are saying, but look at the UK. In the UK, legislators are also in the executive, and they therefore handle money. No, wrong analogy. Wrong analogy. That is their latest argument. In the UK, not all legislators are in the executive. Is it true? Only a few. And those who are in the executive do not have this money like CDF given to them at constituency level. If you are, for example, you are a minister for finance, you handle it at national level with a lot of oversight. You are not the one who can influence that. So CDF, I think that the Supreme Court has done well. So I just wanted to say that in enforcement, we still have certain challenges which we could do better. And so those are some of the issues of moving forward. Moving forward, also there are issues of reform. So I want to mix the questions of moving forward on implementation, enforcement, and reform. I want to mix some of them. Take some of the examples that we need really to move forward on. The question of who are the people of popular sovereignty versus state sovereignty. Before 2010, the issue of state sovereignty was much more pronounced. And that relationship, that difficult relationship between state sovereignty and popular sovereignty has not been clarified enough, especially on the issue of committing Kenya to international instruments and materials. By the way, this idea of once the state has ratified a law, it becomes part of national law. I think Irungu Horton and others will tell us that it was partly because of the human rights groups and environmental movement that had thought that, and the gender movement that had thought that Kenya was lagging behind in so many international instruments in terms of enforcing them. But to what extent, even issues of debt is an international commitment, isn't it? To what extent is there public participation in a number of these international commitments? To what extent is the executive many times involving the people? That's a difficult area that we really need to look at. Then there is the issue here of is public participation, again, part of popular sovereignty. Has it, although the judiciary has been clear, has public participation, do you have a sense that it has become mechanical, ticking the box? At county government level, national government level, get people into an hotel room, a few of them, whom we have actually appointed, or selected, they sign some papers there that their names and a few hours, days, and things are, some documents are read to them, and then, okay, there was public participation. In some cases, it has become so mechanical, so much of ticking the box. The Bill of Rights, second issues of Bill of Rights, which also has been debated quite a lot. Are there areas that we need to implement, to enforce and reform further? Absolutely. Oh, by the way, on that issue of reforming popular sovereignty and people's participation, we need a lot clearer law on public participation at national level and at county levels. Then the issue of Bill of Rights, questions of diversity has not